805 area code, California. Is this Gene?
Yeah, this is me.
Jean Keating, welcome to High Frequency Radio. How you doing, sir? You doing okay today?
Yeah, I'm doing all right.
Great. I see you just came in. Did you hear what I was just talking about with this taxes and putting liens on public officials and all this type of stuff? You want to comment on that?
Well, what did he file with the court? Did he file a complaint? What did he file?
Well, the judge said he did not file it in the form of a complaint, and so the judge did not really understand.
Well, why did he file it? And what did he file?
Well, what he did, I didn't see the paperwork. I'm reading this from the news. This just came over the news. This is up in Wisconsin, so it's on the news. I haven't actually saw the case file, but the guy, he filed
what is his name?
Cornelius Hill. You can Google him, and he'll come up. You can call him a sovereign citizen. Hill, 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 Cornelius Hill.
Right. Well, the problem you have is that these United States district courts are privately owned courts. They're owned by the United States Attorney's executive offices out of Washington, D.C.
Right.
They're not a court of record, and they're not a judicial court. Ask the judge if he's got an oath. He doesn't even have an oath of office. It's all privately owned.
Yeah, I kind of suspected that because that's why they don't let television cameras in any of the federal courts. I say, man, if these are the courts of the people, why you can't bring television cameras in here? It's like they don't allow any cameras in here.
Rules. None of the judges have an oath of office, and they're not a judicial court. Where does it say in the Constitution that you have a United States district court?
It doesn't.
Well, it talks about a district court of the United States, small d and small c.
Well, that would also be in Article 3 because these are territorial courts that Congress has instituted by statute. Am I correct?
If you go and read the original Judicial Act of 1789,
that's right.
September 1789, it calls them district courts of the United States, and there's 13 of them set up under There's 13 judicial districts. And they set up a judicial court in each district.
Now, these districts, these are territories of the United States, kind of like franchises from, because, the United States is in Washington, D.C. This is coming out of Article 1, Section 8, Clause 17. So these districts that they've set up all over the country, this is to adjudicate insular possessions of the United States, which would
they're saying these courts are set up under the Buck Act as territories. Okay. They're territorial administrative courts. They're not constitutional courts. The judge doesn't even have an oath of office.
I noticed that I've never seen a U.S. District Judge's oath of office, and I don't think anybody has.
Well, if you go ask the Attorney General doesn't even have an oath of office. They're under Interpol. So is the IMF fund. The IMF fund is under foreign control. It was formed under the Bretton Woods Agreement. They don't have an oath of office. He's not the Secretary of the Treasury. He's the governor. How can you hold two offices? Under Title 22, Section 2. Go read 286 of Title 22. They're unregistered foreign agents with no oath of office.
Well, then how do they get jurisdiction? How are they getting jurisdiction? How are they doing what they're doing? What gives them? Is what they're doing wrong, or is what they're doing right?
No,
because the American people are ignorant.
What are you talking about when you say what are they doing? Where are they getting their authority? What are you making reference to?
Where are they getting their delegation of authority, and what grants jurisdiction to come and arrest people, take people's property, take people's liberty, all these different things. If they don't have an oath of office,
they do it under contract.
Right. Contract makes the law.
They don't have any. They don't have any authority. They're not a. Go read Title 18, Section 3231. The only court that has jurisdiction of violations of the Title 18, the criminal statutes of the United States, is the District Court of the United States. Here, I'll read it to you.
Yeah, go ahead.
So it's not a criminal case because they don't have jurisdiction. And everybody goes in there and submits to their authority. They go in there and contract with them. There's nothing to prevent you from contracting with them.
Okay, well, wait, hold on now. Some of us, they just show up at the door and say, hey, I have an indictment right here. We have several people ready to testify against you. Turn around, put your hands behind your back. They take you into a federal building. You may not ever see the street again for the next 5 to 10, 20 years or whatever. And we're sitting here saying that you contracted with them. At what point have you solidified a contract? Was it with the driver's license, the Social Security card, the utilization of Federal Reserve notes, a marriage certificate, a birth certificate? What are these minimum contacts? What are these provisions that substantiate that there is the existence of a contract that gives them the authority to do what they're doing?
It's the birth certificate. Who's the person on the birth certificate?
It would have to be a legal fiction entity.
Well, it's not a legal fiction. It's a legal entity.
Legal entity.
It's a dead person. Who do they always put on your birth certificate? They put your first name and your last name. Okay, what is the first name?
The first name is your name, and the second name is your family name.
Well, your first name is not your real name. The real name is your last name. So they should have the last name first and the first name last.
Oh, wait a minute, Gene. How can your last name is your family name, Gene? That's your family. So how would they explain that?
That's who the estate is passed down through, is the family name.
That's right. Makes sense.
Well, they don't put your family name on the birth certificate.
That makes sense. The
inheritance, the estate, is established through the surname, the father. Well, they got the mother's maiden name on the birth certificate. That means the mother had a child without a father. You got a bastard and illegitimate child under Deuteronomy 23:2. And here in California, the hospitals are the ones that are committing this fraud. And what they do is destroy the birth records. The nurse at the hospital that fills out the documents destroys all the records after 7 years. So you're presumed to be abandoned or a missing child, so the state or the county assumes the role of parens patriae as the father. And
Right.
since you're intestate, you're not a beneficiary, and you're not a heir. They assume the role of the father over the child. And you go in there and identify as a dead person.
You know, that's
hang
a
on
funny
a minute.
thing.
I got a call. Hang on.
Yeah, go ahead. It was an interesting thing when he comes back. That's real strange because I actually had someone tell me this, y'all, when I was first getting into this. An individual who knew a lot about this and knew a lot about what was going on. He told me, he said there are a lot of people in this country. Well, he didn't say a lot of people. He said there are sections of people in this country who have this information, and the whole community has this information, and they live together in communities. And when the child is born, they say they have someone in Washington, D.C., who's on the phone, and as soon as the child is born, they tell their person in Washington, D.C. the child has just been born, and then this particular person goes around and files paperwork at 7 different agencies. Now, he didn't tell me what those 7 different agencies were, but in my research,
when you spell a name, a person's name, it has to be in proper grammar. You don't spell it in all capital letters. That's called a capatonym or a portmanteau or a homograph. And what it is, it's a foreign language. And anytime you register a document in a foreign language, there has to be an interpretation of what the words mean. The foreign language. Go read Title 50, Section 19 of the appendix. So what you have is a document in a foreign language. It's not interpreted. It doesn't have anything to do with a person. This is a rule of statutory construction or a rule of grammar. You do not spell English words in all capital letters. The only words that are spelled in all capital letters, and you only there are persons, places, or things that are proper nouns, and you only capitalize the first letter in the name. You do not capitalize every letter in the name. That's a fundamental rule of grammar. So this violates all the fundamental rules of grammar, so it can't be a proper name. That's number one. So what the hell is it? You're going in there and you're using this name on legal documents, and you don't even know what the hell the word means. In fact, it's not a name. Because a name isn't spelled in all capital letters. The only jurisdiction that they spell names in all capital letters is in Admiralty Maritime. And what they do is, and this is in the book, The Law of Admiralty by Grant Gilmore, and he says that what they do is they make the vessel or the ship into a juristic person. And then they get you to come in there and testify on behalf of. That's what everybody does. Everybody goes in there and identifies himself as a legal fiction. If you're not that person, why are you going in there and identifying yourself as that person?
Well, how would you identify yourself? What's the proper way of identifying yourself?
Well, you use your last name first and your first name last, and you spell it in lowercase. The only letter you capitalize is to be a proper name. It has to. You know that. Then you go to grammar school. Did they teach you English grammar in high school?
Yeah, but let me ask you this: when you're in court, okay, all the arguments, I'm not that name argument is gonna get you into trouble. You know, people who have, you know, gone into court and say, well, that's not me on that piece of paper. You know, that's not, and even you have said that on some, I've seen on some of your documents. That's not the argument that you go in there utilizing is that's not me on that piece of paper. You know, they already know that's not you on that piece of paper.
That isn't you.
Isn't. So what capacity are you appearing or not appearing? You know, because here we say third-party intervener under Rule 24, so forth, and you know.
Well, the first thing you got to do is you got to go in there as you got to have you got to be a person that has standing,
right? That
has capacity to make an appearance. Go read Rule 17 of the Federal Rules of Civil Procedure.
Right, real party and interest. But let me ask you this.
And who has standing and capacity to bring an action in a court? Right.
That was my next question.
Well, it's the administrator, executor, conservator, guardian, bailee, bailor, trustee. Those are all probate terms. You're going in there and appearing as a dead person under Rule 601, under the Dead Man Statutes, and you have no capacity or competency to say anything. That's why they don't listen to you. And that's probably what this Cornelius Hill is did. I haven't seen any. Where's his paperwork? Show me his paperwork. Like I'll tell you what he did.
Well, like I said, he's in Wisconsin, and this is on the news. And they have some of this paperwork on the internet. I found some of it on the internet at, let me see where this is, at law.justia.com. I don't know if you have access to my chat room, but I just put the link up in the chat room where you can read it in the chat room. But I don't have any of his paperwork, but apparently, he was stating that he had already informed and noticed the proper parties that he was a real living soul, that he wasn't dead, and I don't know if he stated in what capacity, whether he was the executor, administrator, and all that of this
particular. Yeah, but what
name
did he use? If he used his first name first and the last name, he's a dead person. He's going in there as a dead person. You can't go in there as a dead person and do anything.
Well, let me ask you this. Do you want to go into their courts at all?
Why is he
going in there at all?
Why is he going into their courts?
I don't know. I don't know this man. I don't know this young man. I don't know him personally. I don't know him.
Well, here's the state of Washington. This is it's the state of Washington.
That's Wisconsin, isn't it? I thought it was Wisconsin. Let's see. Let me look at it.
Financial institutions. This says there's a Cornelius Hill, and you got to look at his paperwork. I'd have to see his paperwork first.
Right.
You can't go. This is a criminal complaint against the Cornelius Hill.
All right. They gave him 5 years in prison for putting a lien against a judge. That's what it was. It's called putting a fraudulent and fictitious lien.
Cornelius Hill. This is in Ottawa, Wisconsin. And there's a criminal complaint. Well, you got to go over the criminal complaint to see what he's being charged with a crime. This is all corporate shit. Yeah,
of course. Of course. It's always all corporate. But you can't get. They want you. You can't even ask them about that or anything, and they're never going to tell you, that it's corporate or anything like that. But it's always corporate. But it's sovereign citizen. It says, let me read it. I'll read it to you exactly what it was. It was government does not grant rights. I'm looking. They call him a sovereign citizen.
Well, he says here he submitted for filing with the financial institutions a financing statement relating to a security interest and the real purpose and property of Chad Niels, whom he knew or should have known that the contents or part of the contents to be false. In other words, he filed a false and fraudulent document.
Right. He put a lien on a judge, a police officer, and I think a couple of other...
Well, this doesn't say that. This says that he filed a financing statement relating to a security interest in real and personal property of Chad Niels, whom he knew or should have known the contents or part of the contents to be false, sham, or frivolous, contrary to Section 943.60 of the Wisconsin statutes.
Well, let me read what it says right here. I have the news report on it. It says an anti-government activist shut down several courtrooms across southeast Wisconsin on Tuesday afternoon because the judges were called to court to testify against him. Cornelius Hill of Milwaukee is accused of filing millions of dollars in false liens against judges who faced him in court. A half dozen judges from Milwaukee, Waukesha, and Washington stepped off their benches to take the witness stand as victims. Prosecutors said Hill filed false liens against the judges after they presided over his civil and criminal cases. Hill claimed the judges owe him debts ranging from $500,000 to $210 million. Ever purchase anything from Mr. Hill? Prosecutor Roy Cordy asked Judge Jeff Conan. Not that I know of, Conan said. Ever enter into a contract with Mr. Hill? Corte asked. No, Conan said. Hill said he's a lone voice speaking against a government that's conspiring against his people, so he's acting as his own lawyer. Having an attorney would still be a conspiracy because everyone is colleagues and associates of each other, Hill said. That made for some curious cross-examination. I don't know what you're talking about, said Dominique Amanto, a retired Milwaukee County Circuit Court judge. You've really lost me now. The case affects more than just the judges in the courtroom. Records show the list of alleged victims include judges, police, attorneys, and a list nearly 3 pages long. The judges did not comment. One judge said off camera that the case is more than a waste of limited government resources because the liens can appear on credit reports and take a personal toll on the victims. The Department of Justice investigated Hill's case, and it has taken a year and a half to prosecute. And I'll put that in the chat room.
Where is this guy at now? Is he in jail or what?
Yeah, he's in jail.
You gotta explain what's going on. You can't just comment on something based on the information that you're given.
Well, like I said, somebody just gave this to me, and I'm just reading it off the internet. It was a news report. It's just a news report coming in. I don't know anything about it.
Phony lien filer convicted and faces a maximum of 72 years in prison.
Yeah, that's got to be an old news report. He's been convicted now, and he got 5 years and 5 years probation. He got 5 years and 5 years probation.
Well, this says 72. He got convicted. This is September 12th, 2013.
Okay, maybe he did. I don't know, but he was convicted. He got convicted, and it was for filing liens. But if you want to speak about putting liens on public officials, can you put a lien on a public official?
Well, yeah, of course you can. They're not public. Are they public officials? Do they have an oath of office? Well,
yes, they do.
How do you know they have an oath of office? Have you seen it?
Well, with the state court judges,
for you. None of these, all of these courts are chartered courts under a charter. If you don't believe me, go into the county. This is the county circuit court in Dane County. This is the county court. Go in there and pull the charter and see if the court is a judicial court. It's not a judicial court. It's an administrative tribunal.
Now, when you administrate something, when you call it an administrative tribunal,
the judges are not judges. They're administrative. They're administrative judges.
Administrative, whenever a judge enforces a statute, he's acting ministerially, not judicially. He's just following direction. And this is why it's important to complete some sort of administrative process. Is that not correct?
Well, yeah, you got to, you'd have to go in there and find out why he doesn't have an oath of office.
But wait a minute. Now, the state court judges, you can go down to the Secretary of State or the probate office, and it's funny you said it's all probate terms, because in Georgia, all of the judges, the state court judges, this is on the state court level, not on the federal level. The state court judges have oath of offices that are filed with the probate office. You have to actually go to the probate office to get their oath of office. And or you go down to the Secretary of State to get their oath of office.
And what are they doing? Now, they're acting as the administrator. Every time you go into court, the judge is acting as the administrator or the executor of your estate. Every time you go into court. And that's administrative. That's not judicial. Probate judges are not judges. They're officers. They work under the probate department.
Now, what is the subject of the action? My understanding is a bond, a bid bond. Is this what, how do you, once you are in this situation, what steps do you take to get out of this situation? Is it the redemption of this bond? I remember back in the day, we used to all go into court and we'd say, give me the bid bond. We'd actually go in and ask the judge for the bid bond. And we would see everybody's face just start to look real crazy when you would say that. Everybody would get nervous, you start talking about a bid bond. So let me get the bid bond. And they'd be like, bond, what do you mean? No, there is no bond. You start saying all this stuff. So if this is admiralty and it's dealing with bonds and they're probating your estate, they're probating your estate to pay a debt. Am I correct?
No, they're bringing it. It's a tax issue.
Right.
It's a tax charge. It's not a criminal charge. It's tax evasion is what they and they have to have a bond in order to indemnify them against the tax. Ask them if they have a bond posted under 2032A.
$2032A. Now, what statute was that? 2032A.
It's Section 2032A of Title 26.
Okay. $2032A. Okay. And so
everybody goes in there and consents, identifies himself as the defendant.
Not came to the conclusion a while back.
He went in there and contracted with them and identified himself as the defendant and submitted to their bogus court. Notice how they spelled his name on the paperwork. It's Cornelius Hill.
Okay, now I had come to the conclusion that it's all a tax. I actually saw you do a video where you were actually talking about it's all a tax. It's all a tax. can you elaborate on that? Why is it all a tax? Why is everything that we're dealing with is about taxes?
Well, because you haven't paid the taxes on the decedent. They're making you the trustee. Because you're using his name, you're representing yourself as being the estate of a dead person.
And you need to pay the taxes on it.
And you haven't paid the taxes on it.
Now, how?
Go read the treatise on Zero Your Account. It's on Vanguardian. He tells you right in there that all criminal charges are a tax charge.
So is Zero Out Your Account? I know Zero Out Your Account, they said they had one little minor flaw, and that was the filling out of the 1099 OID. But I felt like Zero Out Your Account was a very, very well written document. There's another document also where our freedom
people are doing 1099. Everybody that's doing a 1099, you can't file a 1099 using a dead person's name. That's what everybody does.
Okay, so how would you file it if you can't use a dead person's name?
Well, you use your real name.
Which is your last name first.
Your last name first and first name last.
All right, interesting. There was another document, Zero Out Your Account. It's funny that you brought out Zero Out Your Account. I saw that document a long time ago, and there was one other document I'm looking forward to. It's kind of in that same vein. I wanted to ask you about where he actually goes in and he's talking about the courts and how, the criminal cases in particular, and how they are tax related and how to actually go about discharging the debt. Is it possible to discharge the debt? I've had some people come on here. They talk about surpluses, using surpluses to offset obligations, using the payment bond, performance bond, and bid bond, giving international bills of exchange, all these different things. Okay, so how do you come into the courtroom, I say, okay, look, I know it's a debt collection. It's a debt collection. Use taxes. You saying because the IRS are a debt collector. So, all right, I'm willing to pay. I'm the executive of the estate. I'm going to authorize all public officials in here to, and I'm going to willingly, without any argument, I'm not trying to traverse any charges or anything like that, I'm going to give these people what they want. How would I go about doing that? Or is that possible? Is that even right? Is that the right way to even approach it?
Well,
or do I need to argue jurisdiction?
Read what he says in there. Oral contract, written contract, and performance contract. It's the most damaging to us. If we act like a defendant and argue law or resist zeroing our account, we are in commercial dishonor. You go to jail.
That is what I teach. Do not participate. It's one of my 4 rules. Do not participate in public controversy. Yeah, the other document is the nature of the remedy. I don't know if you've ever heard of that, but the nature of the remedy actually goes into all of that, too, talking about it's all the tax and filling out the tax forms. Real interesting. It's all taxes, but I've come to the conclusion that the answer to everything, because when I started studying trust law automatically leads into tax law, because, if you're going to maintain the privacy of a trust, you got to understand jurisdiction and minimum contact, and in order to maintain the privacy of your trust, not to go within the United States or conduct any business within the United States. And you begin to see, and you can kind of see, this is kind of applies to everything. So are we looked at as merchants doing business within the United States? Is that what this is really all about?
Yep. And you owe a tax. And he owes the tax because he's identifying himself as a taxpayer.
Wow. Let's switch gears real quick. Let's go to the foreclosure arena. Now, we got a lot of people listening on this call losing their homes with the foreclosures. I mean, how, like, in particular, we got a lot of people, they've already been foreclosed on. They are in a dispossessory or unlawful detainer. I mean, is there hope or is it just too late? Is it just too late? Should they go in and try to argue jurisdiction and say, hey, look, these people don't have standing, they're not a real party in interest, this court doesn't have subject matter jurisdiction? I mean, how would you approach that, or can that be approached correctly?
Well, they don't. It's all in rem. It's an in rem proceeding. Because it's against property, and state courts do not have. You go read Title 28, Section 1333. They don't have jurisdiction. Everybody goes in there and lets them adjudicate it. Let me ask you a question: do they own the property? Do they own the collateral?
Well, my understanding was this. Okay, when I look at it, you tell me if I'm wrong or not. They placed all of these properties or the rights, title, and interest, the promissory note, not the promissory note itself, but the rights, title, and interest to the promissory note has been transferred into a trust, a private trust. And it is an irrevocable trust.
That's not germane to whether the lender owns the property or not.
Well, nobody can own it. They don't own it. I mean, because nobody really owns this, because that's why I'm saying it's been transferred into a trust, because it's the rights, title, and interest to the particular trust. And the promissory note, whoever is the holder of the note, should have a claim against the obligation, with which they never produced the note, obviously. But it's in my study of these private trusts, which are irrevocable, the trustee is kind of considered to be the owner of the trust, of the trust corpus. So could they?
Yeah, but the trustee is representing the lender. It doesn't make any difference whether it's a trustee or a beneficiary.
Right.
Right. Do they own the property? Is the issue. Did they file a preliminary change of title and ownership form? Huh?
I would say that they don't own the property,
then they don't have any security. They don't have any security to a lien interest. There's no sale and repurchase agreement. That's what it really is. If you read Adam Levitin, people don't know what they're doing when they go into court. Is what the problem is. They're not bringing up the right arguments in court.
Well, it would seem like the right argument would be that they are not a real party in interest and do not have standing before the court. I guess that would be the primary thing, correct? They don't have standing.
They're not the lender.
Then they don't have standing. They're not a real party in interest, but they're not the lender. So only the lender.
They don't rebut the presumption that they're the lender. Is what the problem is.
Yeah, I've actually heard people say you can go in court and ask them to state for the record whether they are the creditor. Direct the judge to direct them to state for the record whether or not they're the creditor. Would that be a feasible defense to actually go into court with?
Well, I don't. I try to stop it before it gets into court.
Right. Well, so then that means if we go to stop before we get to court, we got to stop it before they foreclose. Because obviously, after they foreclose, you know.
Well, they're not foreclosing; they're forfeiting it. They're doing a forfeiture, not a foreclosure. You're using the wrong terminology.
Okay, explain that. That's interesting. It's a forfeiture.
Well, a forfeit. What are forfeitures? Forfeitures are tax issues.
Right.
So you're getting around to what the real issue is, the tax issue. Ask them if they filed a statement declaring the property as foreclosure property. No, they didn't. Ask them if they filed a tax return declaring the REMIC as a real estate investment trust. No, they didn't. Well, so where does the court get jurisdiction?
They get jurisdiction because we acquiesce to their jurisdiction.
Well, they go in there and they argue the issues in the court, and they're not arguing the right issues. Nobody brings up the title issue that the lender doesn't own the property.
But
what you ought to do is you ought to get a group of people together, and we'll have a seminar.
Yeah, we got to do that. We're in California, and I was trying to determine. I think we could do an online seminar, and because see these people, I got a lot of people listening right now. It's a whole lot of people who are listening all over the country. I mean, we got people in New York. We got people in Los Angeles, Miami, Chicago, Texas, Georgia, Tennessee, Pennsylvania, Maryland, Ohio, Michigan, Montana. We got a lot of people.
I got a case in New York where it was 3 commercial loans, and the judge threw out all 3 cases.
New York got some nice little statutory laws up there. It seems like they're debtor friendly up in New York too a little bit. So does Illinois.
Well, that's because they told me these 3 attorneys that I contacted that are representing my client said I was full of shit, didn't know what I was talking about. They're using my stuff now. I sent them a 50-page treatise telling them what the problem was. You notice that the bank never comes into court and gives fact testimony as a fact witness. How can a plaintiff come into a court, file a complaint, and never make an appearance and give any fact testimony?
Now, check this out. I just issued a subpoena for the bank representatives to come to court, and the judge threw it out. I'm like, how are you throwing out? We issued a subpoena to check them for documents and a subpoena for these individuals to show up, and the judge threw it out. Now, that should be grounds for an automatic appeal. If you want to subpoena,
why are you subpoenaing these people in the court?
To come testify, like you just said. The bank does not ever show up to testify. How are they, you represent, how is the plaintiff not making an appearance? An attorney...
Well, the court doesn't have subject matter jurisdiction. Are you arguing subject matter jurisdiction?
I've already argued subject matter jurisdiction. That's my first argument all the time, that they're not a real party in interest. Because if they're not a real party in interest...
Did you put in a motion to dismiss?
They rule over, yeah. Put in a motion to dismiss. That's the first thing that goes in, and then they dismiss that. You know how these people try to railroad you and run over you. And trust me, there's a lot of people out there who are hip to the court not having jurisdiction. And they're sitting there and they're going in there arguing these cases and they still can't get these cases thrown out. They're just getting their property stolen. That's why so many people are up in arms now, because people are finding out that the banks haven't even made a loan. Okay, they haven't even loaned you any money. We can just start right there. They haven't loaned you a dime. There's no money. We're creating the money with our signature. They don't have any money. They're bankrupt. They're bankrupt. It's on the public record. So they can't even loan you anything, number one. So,
let's take your case. Where is your case at?
It's in Georgia. It's a case in Georgia.
And is that a judicial state or non-judicial?
It's non-judicial. Just like California.
And what's the disposition of the case?
Well, the disposition of the case is the judge just ruled to alleviate a term. We threw out the subpoenas, and now she's asking for. She basically told, I'm not in Georgia. I'm in California too, so I'm getting all this secondhand information. I wasn't in court, but the court is asking for something akin to a more definite statement in order to convince the judge why she shouldn't throw this case out. Now, the client is the plaintiff. This is not a defense. She actually sued the bank for quiet title. So it's not a foreclosure per se. She actually went in. It's Everhome Bank, which is now defunct, and Federal Home National Mortgage Association. Going to these two particular individuals, and they are the defendants. And, we put in all this evidence using, showing that they're not real parties in interest. They don't have a note. They don't, and then, okay, well, we're going to call this. They try to take a deposition. They try to get you to testify against yourself by giving you a deposition. And
okay, what evidence did you put in that they didn't own the note?
Well, you want to subpoena those documents. Whatever. The only evidence you can is the only notice you requested. You do a verification of debt request, and you request evidence of this. You request some sort of affidavit from some officer of that corporation who can bind that company, and to provide, because they're not going to provide you the actual promissory note. They're going to send you a copy of it. Well, send me something, because this needs to be verified. And verification means that it has to be affirmed or sworn to under penalty of perjury. Send me something
They don't have the deed of trust. What are you arguing the note for? It's not the note that they're foreclosing on. It's the deed of trust, the lien.
And we argue that too. Provide the original deed of trust. You go in and you say you argue because they try to proffer into evidence copies of documents, and then you object to it. You ask for you say, well, objection, Your Honor. We need someone here who will validate the validity and veracity of the contents of those documents. This attorney doesn't have firsthand knowledge of anything. And I've done this in court and actually been successful. I've had judges actually, I've objected every time the attorney tried to talk. I've objected. Objection on hearsay. Objection on hearsay. I don't even let him talk. He open his mouth up because he doesn't have firsthand knowledge of anything.
Well, yeah, but there's more to it than just hearsay. The attorney wasn't present when the loan documents were filed, and the complaint's not verified. Did you bring up the fact that the complaint's not verified?
I just said we need someone here who can verify the veracity and validity of the contents of those documents. That's what I told the judge.
If they file the complaint, then the complaint's not verified.
They have, I think, on some of these foreclosures, they have a little something that looks like a verification at the end. It looks like some modest type of. Yeah, but you're correct. They file complaints. The complaints are never verified. They're never verified. You're absolutely correct on that.
Well, the attorney can't come in there and give fact. So it's not fact testimony. So did you do a motion to strike the complaint?
Well, we get a court reporter and you come in with not a motion to strike complaint, but a motion to dismiss for lack of subject matter jurisdiction. You know.
Well, you should bill a motion to strike the complaint.
And what if the judge rules against your motion? Because everybody knows these judges
rarely. Well, what if you get run over by a Mack truck? I mean, you know, you're
yeah, you can do what else. You can do what else.
We can sit here and conjecture all day long. What if this? What if that?
Right.
You got to deal with what is, not supposition. That's
true. But you do have to prepare for some contingencies, make some contingencies.
Well, you have to. Did you ask them for the CMIRs, currency money instrument reports? To
no,
show
I
that
asked them for that.
But of the funds that were transferred at escrow?
Well, I asked them for
Did you ask them to produce the preliminary change of title and ownership form as a sale and repurchase agreement at closing? No.
No. What I asked them for is the FR 20. What I asked them for is the FR 2046 balance sheet, 1099 OID, the call reports. I asked them for a.
What call reports are you asking for?
The 60. Well, I forgot the call reports.
You got to know. You got to know what the call report. You know what call reports are?
Yeah, the call reports are the when the loan goes into default, if I'm correct.
They have to show if they have a loan, an outstanding loan, they have to report it as income.
Right.
Well, did you ask them to produce the RCN and the RCP call schedules?
Yes, we put all that on it. That's exactly right. I'm looking at it now. But we also asked for the 1099 OID because the 1099 OID will also demonstrate if they've made a loan, they should have reported it to the IRS. Am I correct?
Well, you don't report income on an OID. That's for an original issue discount. That shows who the issuer was. And they have to file, you should have asked them for the 8281. Not the OID. They have to file an 8281 before they file an OID.
I put the 8281 on there too. I put the 8281 on there as well. But the thing is that because the 8281 it has to be filed in conjunction with the OID. But it establishes who the issuer and the recipient is, and if they are claiming to be the issuer, then they should have that on that document.
Well, they don't have to. What they do is they're creating a presumption. You should subpoena the CMIRs in, the currency money instrument log, the money net daily transaction log. They have to produce that under the Bank Secrecy Act.
Okay,
tell them you want to see who the source of the funds was at closing of escrow.
Okay. Source of the funds at closing of escrow. That makes a lot of sense. Source of funds, closing of escrow.
Who was the source bank and who was the target bank? You have a right to see that. They can't deny that.
That was going to be my next question. Where does my right in requesting these particular documents derive from? Is this going to be a Freedom of Information Act request, or is this governed by some type of statutory code?
The Bank Secrecy Act and the U.S. Patriot Act require that.
Okay.
And all these courts are military tribunals under the U.S. Patriot Act.
Great.
They cannot produce
great information.
That's
great information.
They cannot prove. What you should do is let's get a class together, and I'll show you how to stop all that stuff.
Okay, we'll do that. And we'll schedule it for this week. How about Thursday? We do it Thursday afternoon. What's your schedule looking like? I'm making a commitment on the air. We got a lot of people. Before we do that, though, before you answer that question, we got a lot of people want to ask you some questions. You feel like taking a couple of calls? I mean, a lot of people in queue want to talk to you.
Yeah, go ahead.
Okay, cool. Let me start in. Somebody said I'm in for the. There's already people saying they want to come to the class. Let me go to area code 267-3782. You're on High Frequency Radio, Pennsylvania. What's going on?
Yes, good afternoon to the both of you.
Good afternoon.
Yes, good afternoon. I can't say where I read it, but I had read somewhere in reference to the names, and I read that when you put your last name first and your first name last, then that's out of proper order. And anything that you write in all caps, as well as if you have any initials in the name, then it's all in error. So could Jean repeat where to find that written in law, that we've been writing it backwards when going in the court, is one question. And the other thing is, if you've already been in one of these municipal courts and
that's why they put your first name first on the birth certificate and the last name last, because you don't have a father.
Okay, and I guess that's why they send paperwork to offense court when you get married or something. I don't know. But I'm just saying, so...
What I did is I went down and got a passport. On my passport it says Keating Jean, not Jean Keating.
Okay.
And I filed an SS form with the IRS declaring Jean Keating dead. I got an EIN number that says that.
Okay. But like I said, in the rules of grammar or anything, or in lawful rules, is that written somewhere where you just said about making it the opposite?
You have to spell the last name is the family name is who you are. You're not Jean. I'm not Jean Keating. I'm Keating Jean.
No,
I hear what they didn't want to put that on the passport, but I made them put it on there.
No,
I know what she's saying. I have a document. It's a court document that explains the correct appellations of the names and how they're supposed to be written. I can't remember it right off the bat, but I do got it in my Dropbox. Where this is, it's called a Styles Manual. That's what it's called. It's called a Styles Manual. I don't know if it's a military Styles Manual or what, but it talks about when you write the name in all capital letters and all these different things. They're giving these instructions.
When you spell a name in all capital letters, it's not a name.
Right, I understand that. I'm in agreement with it. The only thing I was trying to find out is in law, where could you find that written to back it up? That was basically my question in reference to that. Then the other question was, so if you've already been up in one of these municipal tribunals and they don't have jurisdiction, but you've been communicating with them, so have you contracted, and should you ask the prosecutor for discovery? I guess is my question.
You want to ask the prosecutor for the what?
For discovery.
Well, no, because they don't have subject matter jurisdiction.
So discovery doesn't even need to be discussed, is what you're saying.
Right. Are you talking about a foreclosure case?
No, I'm talking about in reference to traffic tickets.
What gives them jurisdiction in a traffic case is the driver's license. You have a driver's license?
At the time of the incident, yes.
Are you in a commercial activity?
No, I'm not.
Are you in do you have are you in a revenue taxable activity?
No.
Well, then why do you have a driver's license then?
In my ignorance, I didn't know.
Let me also speak on what you just said about the appellation of the name. First of all, it goes against the rules of English grammar. I've done a lot of research on that myself. You're not going to find anything.
The proper name
is,
the only thing you capitalize on a name is the first initial on the name. That's rule number one. And number two is you always do the last name first. Because on the birth certificate, the state and the surname, the family name and the estate is passed down through the father, through the surname. So your proper appellation or name is whatever it's your last name first and your first name last.
Let me give her a book. It's called
Can
the
I
U.S.
ask another question? All right, sometimes in situations, sometimes you're talking about the pass down from the father. Sometimes in certain situations, a woman is married, but the child does not belong to her husband. So what do you do in a situation such as that? And the true father is not on the birth certificate at all, but the married name of the husband. Now, what do you do in that scenario?
So do you have the father's name down as the?
No, the husband's name is put on the birth certificate of the child, and not the true father's name. So, what do you do if you say from this perspective that the name is passed down, the family name is passed down from the husband?
You're saying that the father's name is on the birth certificate?
No, I'm saying here we have a situation where a woman is married. So on the birth certificate is the
yeah, but who is she married to?
She's not married to the child's father.
Well, then it's not her It's not the father is not the father of the child.
That's correct. I'm saying that. So if you have that scenario where the child is not the husband of the wife, okay, they're separated, but you have a child outside of that marriage, but yet that name is on the birth certificate. Well, the
issue is not whether they're married or not. The issue is whether he's the father of the child or not.
Right. So I'm saying if the stepfather's name...
Well, he needs to file the paper. You can file paperwork with the Health and Human Services showing who the father is.
No, I'm just talking about these people are deceased, both of them, but I'm just saying, how do you address that issue when you're talking about the birth certificate if your true father's name is not on the birth certificate from the beginning?
Well, then you should put the true father's name on the birth certificate.
There's a way you can correct your birth certificate.
You can correct. You got to go to they have forms for correcting the information on the birth certificate. And if the guy's deceased,
does it make any difference?
If the person's deceased, then you got to go to probate court. Get the information changed.
I mean, but at a point, if you're up in age, does it make any difference?
What do you mean, does it make any difference? I'm not understanding that question.
Does what make any difference?
Does it make any difference that your true father's name was not on the birth certificate?
Well, sure it does, because the person that's on the birth certificate if the real father is not on the birth certificate, then the child is an illegitimate child. And the state assumes the role of parents betray. Why do you think, you know where all the birth certificates are going? To the cardinal bishop.
That was just an example of, if that was a situation, because I know some people that is their situation. So I was just asking and wondering. But like I said, one parent is dead and one's hanging on, and the child itself is much older. So it's not like they're, young or anything.
Are the parents still alive?
No, that's why I said one parent is deceased and the other parent is at the door. And the child is over 60.
Well, they can correct the birth information and show themselves as the real father.
But at that point, and they're over 60, why would it even be a need? That's what I'm trying to understand.
Well, because on the birth certificate, you don't have the father. So it's an illegitimate child. The child has no father.
But the fact that the way they wrote it on the birth certificate in the first place, from what you're saying, it's still saying that, whether you change the name on there or not. The way
yeah, but you said that the name that was on the birth certificate is not the real father.
Right, but you're saying also the way that the name is written on the birth certificate makes you a bastard child because it's not real. Or did I misunderstand you?
No, I said because they used the mother's maiden name. They don't use her married name.
Okay. So if they use her married name,
then you have a father. You have a legitimate child.
Okay. So does that
but they don't do that.
Does that come from a particular law, like in Roman law or something?
Well, it's a matter of it's not what they do is they use the mother's maiden name and they show her as being not married. So the child has no father. When a woman has a child, she's married to her husband. And she uses his surname or family name, and the child has a father. Otherwise, he's an illegitimate child. And all these birth certificates show that the mother had a child outside wedlock. So he's an illegitimate. That's why Deuteronomy 23:2 says.
I actually did a whole bunch of investigation into marriage.
The of the Lord, even to the 10th generation.
Okay, thank you.
It's illegitimate. And after 7 years, you're either missing or been abandoned, and so nobody's claimed the child. Even the mother hasn't claimed the child.
Let me
assumes the role of the father under parents betray.
I thought
that's
they
the
did
word
that
you want to look up. Parents betray.
I thought they did that any time that they created the birth certificates in the first place, and that you were signing the child over to the state as if no matter what last name was on there.
No, that only occurs when the child is born, when there's no beneficiary or heir of record. Then the estate is intestate because there's no father, because the estate is passed down through the lineage of the father. That's why you have to use the surname on the birth certificate as the father. The mother has to use the surname, not her maiden name.
Okay, thank you.
Let me say this too, real quick. The Styles manual, I put it in the chat room that goes over the appellation of the names. It's called the U.S. Government Printing Styles Manual, Printing Office Styles Manual. It goes into capitalization rules, capitalization examples, spelling, compound rules. Got everything what she was asking about printing, how to print the name and so forth. It's on the U.S. Government Printing Office Styles Manual. That is what the name of it is. Now, back to this birth certificate and this thing with marriage. You know, I was doing some research on the marriage issue, and I saw what you were talking about how it's really frowned upon for a woman to have a child out of wedlock, and or bastardized child. Let's just call it what it is. And these children are kind of, it's almost like, because I know that all this stuff is kind of religious-based at its root. Is this something, I know you just said it all goes back to the Cardinal or to the Vatican. I was listening to somebody else talk about that today, how the Vatican is tied into all of that. what is the significance of all that? How does that all play in? And I understand what she was asking about the birth certificate. She was saying, I thought birth certificates were like car titles. If they got a birth certificate on you, they're claiming ownership of your body and your labor.
And again,
well, they own the name.
Well, they do own the name. They created the name. They created.
Well, that's not your name, though. It's their name.
So why are we even discussing it then? If they own it and it's not your name.
Well, we're not discussing it. We're discussing your real name. We're not discussing the name on the birth certificate. They own it.
Now, wouldn't it be more significant, because this is all commerce, the Social Security, because I noticed you said that you got an EIN number. And that is what I teach, too, to get you an EIN number to operate in commerce privately. Now, is that what you did? Is this EIN number connected to a trust, or is it connected to a...
No, it's connected to your estate.
Oh, it's to an estate, okay. You got a 405 number, an estate number.
You have two EIN numbers. You got a foreign grantor trust, and you got an EIN number for the estate.
Right. Okay, I got you. By the way, y'all, I have instructions for all that, what he just said. Thank you, sister. I appreciate it.
Thank you.
I appreciate. I think very good questions. Very good questions. We'll chat later. Let me go on to the next. Let me go on to the next caller. 561 area code. I'm gonna jump down to Florida real quick. Florida. You're on High Frequency Radio.
Hi. Do you hear
how
me?
you doing?
I'm good.
Yes,
How are you?
I can.
Oh, I'm glad I got in. Well, I had a question for you because I've still been going through the process of providing notifications and writs to the state and to the courts and to FHA and Bank of America about the fraudulent foreclosure that went on with my property. And when I actually go on the property appraiser's website, it shows where the state disqualified the warranty deed sale, and that the only verified deed is my deed, the warranty
in Florida,
deed.
when they go to closing, they have to pay the capital transfer tax on the promissory note.
Mm-hmm.
I have a Florida case that says that they cannot enforce the note unless the tax has been paid.
Okay, so
they never do that. They never pay the tax on the note, and they never pay the preliminary change of title and ownership form.
Mm-hmm. And so the way I'm looking at it, because with my deed, my warranty deed, it's labeled as verified, whereas the special warranty deed is disqualified. And to me, it seems like that's because of the trust, that the trustee, FHA, was not qualified to
what is
sell
your
the
deed
property.
Do you have a deed of trust?
No, I'm in Florida. I don't believe that it is a deed of trust. I think it is a promissory note and a warranty deed.
No, they use either a mortgage security agreement or they use a note.
A mortgage.
Yeah.
They don't use warranty deeds on foreclosure cases.
No, my deed was a warranty deed, and that they sold it.
You mean the warranty deed or grant deed was what you got from the seller?
Yes.
Okay,
and
but
that
doesn't have anything to do with a foreclosure.
No, what I'm saying is that what actually happened to me is I wasn't properly served, and I was out of town. I come back to my house, and a realtor had a sign placed up on my door, and locks placed up on my door, and took over my house.
Foreclosure has nothing to do with it. They don't foreclose on warranty deeds. They foreclose on mortgage security agreements.
Okay.
I've got 2 cases down in Florida. I've stopped both of them.
Okay, but because right now the way I look at it, because I wasn't even properly served, that my house was burglarized, and somebody else is living up in my house whose brother-in-law happens to be a sheriff, so I know they know what's going on as far as the laws are concerned. But I'm trying to figure out now, because I've notified the state, I've notified the Secretary of State, the Attorney General. I provided them with a writ precipice saying that that I was fraudulently foreclosed on, and that I am quieting the title, and that the trespassers on my property are evicted, and that I'm going to be moving back into my property. And now I'm trying to figure out also if I can actually provide a decree of allodial title and quiet title.
Yeah, you can ask for a reconveyance and transfer of. What you should do is you need to get rid of the. I would do a rescission of the deed of trust or the mortgage security agreement.
Okay, because the way that I look at it that's going on is that the judgment, the foreclosure was fraudulent on its face, and that the guy that's in the house now is just trying to take adverse possession of the property by saying that I'm, dead. And that it's his property because he's taking adverse possession.
That's what they're really doing.
Yes, and so where I'm coming from what it sounds like what you're saying is that judgment is void on its face, and that it's invalid anyway. And from what I'm looking through the records, that's what it actually looks like, and that's what it looks like to me, that the state already acquiesced to the fact that it was a fraudulent foreclosure.
Mm-hmm.
And that I should just be able to provide notice and say, I'm moving back into my house with my kids and my family.
Well, is there anybody living in the house?
Well, that's the thing. This is where it's going to be, I'm going to have to do some work, because this guy, his brother-in-law, is a sheriff, and so they're going to know all the tricks in the book of how to try to stay in the property and be like, squatters or whatever else they're going to try to do. So, but what I'm saying is that I'm going to just provide notice and say, and I've already provided it to the sheriff's office also, that I'm going to be moving back into the property.
Let me say this to you. I had a client. He went and filed a foreclosure against the people who were in the house, went back to court, got a judgment, and then moved back in the house, and they came and arrested him. And this was in Georgia.
Mm-hmm.
So, really what happened with you, it sounds like, is I've moved back into a house before. You shouldn't have a problem. If they don't have a judgment from a judge saying that, you were foreclosed on, you can move back in the house. If they don't have an order from a judge, and the real estate agent, I told the real estate agent, too. I told her, you come back on this property, she called the police on me. I came in the property. I had the deed. The house was deeded to me. I wasn't around the property. I came to the property. They had come in and did $20,000 worth of repairs to the house.
Mm-hmm.
All right, and it's like, and they painted, repaired the house and everything, and got a sign out front. And I said no, and I was showing the house to people. I went into the house, told them to get out. This house is under litigation. The real estate agent called the police on me. Police came. I showed them my deed. They said this is a civil matter. They couldn't do anything. And I told her, get her signed and get it up out the yard. She come back on this. She comes back on my property. I'm going to have her arrested for criminal trespass. I did all of that. It ended up on the news, but I know they didn't have the right to do it because they didn't have an order from a judge. You just don't come in and just take my property because I'm gone. If you're going to take this, because that's theft. To me, that was stealing. That's stealing.
Well, see,
you know what I'm saying?
The thing is
that property.
I believe that they have the order from the judge, but what I'm saying is that, but I've been asking for their oaths and their bonds, and I haven't gotten any oaths and bonds, so I'm not sure whether or not it was really a judge or somebody.
Well, you're talking about a warranty deed. They didn't
I
foreclose
have
on a warranty deed.
Uh-huh.
They foreclosed on a mortgage deed. You got a mortgage deed. Where's your mortgage deed?
Okay.
Yeah, Jean, I think what she's saying, though, Jean, is that she doesn't have any evidence that a foreclosure order was signed by a judge who has a bond or an oath of office. She hasn't been provided any information that would demonstrate that the paperwork...
Yeah, but we're not talking about that. I'm talking about she brought up a warranty deed.
Yes, what I'm saying is that was the original... That was the original deed that I had for the house when I put in the purchase.
Right. Yeah, right. But that doesn't have nothing to do with a foreclosure, like you said. It doesn't.
No, what I'm saying is that the person that's in there now has a special warranty deed, and from what I see with the special warranty deed, when the state examined my deed and when the state examined the person that I call the trespasser deed, that deed is disqualified because the bank didn't have any authority to sell the property.
Well, yeah, but are you talking about a foreclosure case? Did they foreclose on your property?
Yes, they foreclosed. I was out of town. I didn't receive proper service, and a judge...
Well, you should do a motion for void judgment.
Mm-hmm. Okay. Well, I mailed them a writ of precipice.
You were out of town for how long, and you're alleging that they served you a foreclosure complaint on you. So they did a default judgment on you, didn't they?
That must have been what they did, a default judgment.
Well,
exactly what it was.
You need to do why don't you send me your paperwork, and I'll tell you what you have to do.
Okay, great. Okay.
Can you copy your paperwork? Copy it. Do a photostat copy on it. Send me a copy of your mortgage deed and your promissory note. Okay.
Deed and promissory note, and then and what's your email so I can send it?
It's JEAN. CEATING @gmail.com.
@gmail.com. Okay, so that's JEANCEATING @gmail.com. Because that's another thing too. I'm trying to figure out where is the escrows related to the property, because a lot of these title companies have gone out of business.
Well, they don't have the reason that there's no. You don't even have a title policy. Do you know that title policy is a security derivative, not a title policy?
I didn't know that.
And you're signing an insurance contract, and they don't have your note because they forfeited the note as a bond to indemnify the title company on the default. Your loan was in default at closing.
Because that's the thing too. Like a lot of the title companies aren't even in business anymore, so it's like locating those people. I don't know where to actually find them. I was thinking the bar,
And what's the funny thing about that, I thought that was all a conspiracy.
Most of the title companies down there in your state are Fidelity National Title Company. They own American Title, Land Title Company, American Title Company. There's a bunch of about 5 or 6 of them.
But they're all they're like a franchise of Fidelity.
Yeah, they're all under Fidelity National Title, which is in Jacksonville, Florida.
Oh, okay.
And I file an errors and omissions claim against them.
Okay.
For title fraud.
Okay. Great. Because that's another thing,
and
too.
insurance fraud. What they did is they collected the insurance on the property. And they're forfeiting the property to pay for the default that they created.
Because I think what actually happened, too, was another thing that happened is that when I sold the property before this property, that the title, it was actually a title company that came to me and asked if they could purchase the property. An owner of a title company came to me and asked if they could purchase my property for their daughter. And so I agreed, and I went through his title company to sell the property. But now, looking back and what I'm learning is that from what it looks like, because there was monies attached to the property, that he just transferred the escrows from that property to himself, and that just gave me the difference of whatever the sale was. And that so pretty much he just transferred the property over to his name and didn't pay for anything. Do you know what I'm saying?
You mean the people that you got the property from, you mean?
Oh, no, I'm telling you about a property, a prior property, like the property that I sold, supposedly sold before I moved into the second property, is what I'm saying is the title company came to me to buy my property, and I believe actually what happened now, looking back on it, is the escrows attached to it. He transferred those escrows to himself, and just took the property was assigned over to him rather than him purchasing anything from me.
Well, what you're saying is there never was a loan or an escrow closing.
Mhm. And so, and that somehow the people that are attached to these title companies were robbing people left and right.
Well, yeah, that's a securities derivatives.
Mhm. Okay. Okay.
Michael Greenberg, the head of the Commodity Securities Exchange Futures Trade Commission, said all these title policies are security derivatives.
Do you
They're
know
not
anything?
Title policies.
Because the thing is I've been trying to figure out, and I know, Yusef, you've gone into it, and I need to go through some more of your your talks. But the thing that I'm really still confused about is the whole financial part of this, the bonds part, the escrow part of this process, and how we were.
That's what he was just explaining. He was explaining how the promissory note is a securities derivative that's used to indemnify. What'd you say, Gene? The title company.
If you go into your insurance code, you'll find out that the note is a bond.
Mhm. Yes, but I'm wondering. I guess if you have any recommendations of a simplified book that I can read to kind of give me a little bit more clarity, because I've listened to your videos and I've listened to Yusef's videos, but just to get a firmer understanding of how the taxes and the bond and the securities are all interrelated.
Well, what they do is they put the bond up to indemnify the title company against default.
Mhm.
They put the loan in default because they never transferred the loan documents to REMIC.
What was the bond? Was it the credit that I put into the note?
No, the bond was the note.
Okay.
You think it's a promissory note. It's not. It's a bond. It's a financial asset.
Okay. And then how did the taxes play into that?
Well, they didn't transfer the loan documents to REMIC, so they're holding all this capital they didn't pay the capital transfer tax on. So they do a forfeiture. That's why all these mortgage loans are forfeitures, not foreclosures.
But who's holding the money? I mean, who's holding the escrow?
The servicing. There never was an escrow. They never deposited any money into an escrow trust account at closing to pay for the property.
What about the release of the mortgage?
Well, ask them for the MoneyNet daily transaction log that shows they were the source bank on the transfer of the funds to a trust escrow account into a target bank, which is your bank.
I thought I was the bank that transferred the money, that I was the credit.
Well, it is. You are. But the Money Net daily transaction log will show that.
Okay. And the bank has that, or does FHA have that? Bank of America or FHA?
Ask the title company.
But if the title company's out of business, I need to go to Fidelity National.
Well,
Title?
they don't go out. What they do is they merge. Somebody picked them up.
Okay.
If you'll give me your information, I'll find out who it is.
Thank you so much, Jean. I really appreciate it. Your talks have really helped me, and you said your talks have really helped me too with trying to at least kind of unravel the fraud. But I still, if you happen to have a recommendation on like securities for dummies, that'd be really great for me.
I'm gonna tell you the truth. A lot of stuff I learned when I first started, I learned from this man. That's why I have him on the show. I mean, it's not too many people I give props to, and I learned a lot of stuff from him, reading his material. So that's why I'm honored to have him on the show. Now, I did a lot of study myself, but what you need to do is file a insurance fraud claim with the Commissioner of Insurance.
And see, that's been another thing too. I've been I sent something to risk management, and they're kind of like playing dumb, like they don't know what I'm talking about. They say contact the governor, and then when I contact the governor, it's just a whistle. I hear nothing back.
Hey, you
so to me, they're acquiescence to it.
Do you file a claim with risk management?
Okay. Well, I sent a notice to risk management. I didn't file a claim.
So you said a notice, you mean to the county?
I sent a notice directly to the treasurer for the state that handles risk management.
Ask them if they have a self-insurance program.
Meaning the self-insurance?
That's handled at the county level. Down in Florida, they have a self-insurance program.
Self-insurance because that was another thing when I asked the clerk of court that this happened through whether or not she had a surety bond. She said she didn't have to have a surety bond in Charlotte County. So in other words, the county itself has the self-insurance, or the county commission.
Yeah.
Okay.
Well, ask her if she handles money.
She's the comptroller.
Well, she has to have a bond then.
Well, she's saying she doesn't have a bond. I know that's
right.
She's saying she doesn't have to have a bond in Charlotte County.
Then she's personally liable. Ask him who's liable for the money then.
Who's liable for the money?
Right. If you have a bond, she's personally liable.
Well,
she's personally liable. Ask her if she has a self-insurance program.
Well, because what the chief deputy sent me a letter because I asked them, I asked her for her bond information, and she had her chief deputy send me a letter saying, well, in Charlotte County, she doesn't have to have a bond, and so that led me to think, okay, well, Charlotte County must be covering her bond, or the county commission must be covering her bond, because she's saying that she doesn't have to have a bond. But maybe she's saying that because it's not called a bond. Maybe it's called like self-insurance, like you're saying.
Well, ask her if they have how do they indemnify them against liability?
How do they indemnify?
Ask them if they have a self-insurance program.
Okay.
A lot of counties have self-insurance, and what they do is the county employees pay into a fund called the self-insurance program.
And would that also be the same case for the judge that entered this foreclosure, or the chief judge?
Yeah, ask them if the judge has a bond. Okay. In fact, they have a new law in which I have a copy of it. I just got it. It's hang on a minute, and I'll read it to you.
Okay, great, thanks. So you said that you to send you my mortgage deed and my promissory note. Is there anything else that
mortgage deed, the note, and if you have the title, who the title company is.
Okay. Wouldn't that be on the mortgage deed or the warranty deed?
Yeah, it should tell you on the deed of trust who the title company is.
Okay, great, thanks.
Or the title insurance.
And I have to go. Sorry, go ahead.
No, go ahead. No, go ahead.
They don't. It's Charlotte County. They've got all of their records blocked. They don't have it available online like a lot of the other counties do.
They passed a new law in 2013 that I'm trying to find it here.
While he's looking for that, just one other suggestion. You asked me what books to look up. Mm-hmm. There's no really specific book I can direct you to. My thing is look up words. Because just like he said, promissory, a bond is when you look up the word bond, you're going to say it says promise. And people don't know promissory notes are bonds. So, just simple things like that will start connecting dots to you. It's like putting together a big puzzle. I mean, that's the best way that I could say it, and it led me to tax law and trust law. That's where I'm at right now.
Well, you happen
because everything is a tax.
You happen to mention, like I heard you on one of your shows, you said, well, when you bring a case, the plaintiff and the defendant needs to put up a bond. So my thing, be bonded. So what I'm saying is that when I was the defendant in this, and they entered a default judgment against me, what kind of bond did they have from me? Was it the mortgage? Mortgage note? I mean, the promissory note?
It's just like he said. You coming into the public, there has to be some sort of bond somewhere, and you have to ask them to produce the bond. Produce it.
But can I just bind them to their bond, and that be my bond? Since they're bringing me in? I mean, there's a way you can hold them liable. Wait a minute. Let me make sure I understand your question. You're saying the thing is that they have to be bonded. These public officials have to have some sort of indemnification in place. And in admiralty, when you're bringing a claim, you have to be bonded. They used to call it a caution back in the day. And I learned that from studying the clerk's practice. It's a document. That's one document that I would suggest that you read, and also Benedict on Admiralty. Yeah, Benedict on Admiralty. Okay.
Yeah, start studying the history of this stuff, and you'll start kind of seeing what you're supposed to do, because that's where it's coming. None of this stuff they're doing is new. And none of it is new.
So what it looks like is that it was a default judgment, because I wasn't even on the scene when all of this happened.
It is a default judgment. If you weren't there, it was a default judgment.
And so, but what I'm saying, what I got to find out is that were they even bonded to even enter any kind of judgment?
It's like he said, put in a motion to dismiss or vacate order for lack of subject matter jurisdiction or something like that. They always answer that. They got to answer that.
And then also, you've mentioned before, now, do these cases, these foreclosures cases, also contribute towards the CRIS and the CAFR accounts?
Yes.
And how do they get paid? How are they getting paid off of my foreclosure?
Gene, you want to answer that?
The state has the chief financial officer invested in Fannie Mae and Freddie Mac.
I'm sorry.
It says it right in I can show you the code section where it says all that.
Oh, you're saying of the county?
Yeah.
Okay, see, because that's the thing. That same clerk, she's the comptroller, the treasurer, the recorder, and the clerk for the county. She has a lot of different hats. So, in other words, that clerk is invested in FHA.
Yeah.
And so where do I get that accounting? Like, how do I request? What's the name of that accounting so that I can request that? Say, the financial statements showing how my foreclosure contributed to their CAFR. Is there an intermediary form that does that, or do I just request how it contributed to the CAFR or to the CRIS?
Well, you need to find out who your title company is. I need to see your loan documents.
Okay.
So I know what you're dealing with.
Okay. Thank you.
It was my understanding that you contact the fiscal clerk would have that information.
For the court?
That's right.
Mm-hmm. That's what I'm saying. The clerk of courts, she has those different hats. She's the comptroller, the treasurer, the auditor also.
Well, I don't know if she's the fiscal clerk though. You need to find out who that is.
Oh, okay, the fiscal clerk. Okay, great. Oh my goodness, there's a whole lot of components to this. And I noticed that when I said I was alive in my last, because they've been blocking me from recording, but I noticed that when I said I was alive, they sent me to a different person than they had been. They sent me to the chief deputy versus the director of records. I don't know if that makes a difference or not, but it seems like once I said I was alive, they sent me to somebody else.
Hey, go ahead and send him your documents. I'm gonna take some more of these calls. Got a lot of people want to ask questions.
Thank you so much. Okay, thank you.
You're welcome. You're welcome. Thank you, sister. All right, let me go back to the phones real quick. It's a ton of people got their hands up. Wow. Let's see. I'm going to try to get the people who've been holding on the longest first. 302 area code 7419. You're on High Frequency Radio. .302.
Yes.
Yes, you're on air. 302-7419. Okay. Move on. Let's go to 33. Let's go to North Carolina real quick. 336-9930. You're on High Frequency Radio. North Carolina, you're on air.
Oh, how you doing, Yusef?
Hey, how you doing? I can barely hear you.
Yeah, I'm on some terrible equipment right now. How you doing, Gene? Wonderful information. I just want to say that I do have some questions, but I'm cleaning out a garage right now, but I'm listening. I love the information. I got other people on the call too that came on, Yusef. So just go ahead and go to the next question and come back to me, Yusef. I appreciate it.
Okay. Let's go over to Cali real quick. 562 area code, California. You're on the air. 562. Turn down your speaker in the back.
All right, brother Yusef, can you hear me?
Hey, what's going on? Yeah, I can hear you fine. How you doing?
Okay, cool. Sorry about that. I was in the gym. I was wondering because basically with the UCC, I know concerning the birth certificate and the Social Security, I put that on the UCC and, as my claim, and considering I'm the only claimant on there, and when you take that into court, how could they argue that?
Well, Gene, did you want to answer that?
Okay, you're talking about what is your question?
Speaking on the birth certificate, how you were saying you can change your name and things of that nature. Well, why don't you just file a claim on your birth certificate along with your Social Security regarding the UCC, and therefore they wouldn't have a claim against you.
Well, because you don't own the name. It's not your name.
Well, once you copyright it, how about when you copyright it? You copyrighting a straw man?
Well,
I copyrighted
you haven't done that, have you?
Yes, I copyrighted my straw man. I also filed a claim and put my birth certificate and also my Social Security in the UCC. and I copyrighted
my
name.
You have a copyright infringement then.
Okay. Yeah, so it wouldn't be a need to, they wouldn't have a claim because you're the only claim holder in due course for that name, and they wouldn't have a claim against you on your birth certificate or your straw man because you're the holder in due course of it, from my understanding, and that's why I did that. So there's no need to go ahead and, switch the names around, or you can do it later, I suppose. But once you file that claim, then you're the holder in due course.
Well, you're not the holder in due course. You own the copyrights to the name. Name is intellectual property. You can file a copyright.
Right. Okay, that was my question. I know it's kind of noisy. I was at the gym, but I was just wanting you to comment on that. I'm sorry about that, Yusef.
That's okay. Okay, so you're saying that you can't copyright the name, Gene. That's what you're saying.
Yeah.
Yeah, I know. I had a sheriff one time ask me if my name was copyrighted. So I know they know about the copyright. Let's see, 646, where are you? 646 area code 4187, you're on high frequency radio.
Hi, how are you?
All right,
just
good.
Want to get back to the foreclosure. That's a really hot topic. I got the judge to dismiss my case. Everybody went away. Now someone else bought my note, and they're trying to come back. Question for Gene. Last time he was on the show, he talked about the way that he does not, participate in their court system is that he do a claim to the title insurance company, also to the state, and also a letter rogatory. Is it possible that we can get an example of one that he's had success with?
Yeah. That's why we should have a class on this so we can, I can give you handouts and that kind of stuff, where you can actually see documents.
Can you talk about that a little more, though?
You mean on a letter?
The claim that you make to the title companies.
Well, we do an errors and omissions claim.
Okay. And the court will honor that, or do you send that to the court at any particular time? Like, what prevents?
Well, I send it to the title company, and I send a claim to the insurance commissioner of insurance.
And they just withdraw totally? They withdraw the foreclosure? Is my question. Just based on your claim.
Well, you file the claim because of a defect in title.
Right. I understand that. I'm just saying when you file the claim, does that, make them put in a motion to, dismiss the foreclosure?
Well, the title company is not the one that's foreclosing. The one that's foreclosing is the servicing company.
Right. All right. I'll see what you have. I'm just wondering, how does that, like in my particular case, for example, I did a combination of stuff. I sent them an EFT. I sent them all sorts of stuff, and they just really backed off. I'm just wondering how, your process would help in a foreclosure situation.
What is your question?
Just wanted to get a bit of an understanding as to when you send out, these claims, how the lawyers are reacting, how the title companies are reacting. Do they become afraid? Do they say, okay, we're just not going to foreclose on this one because they know what's going on?
Well, when you file the claim, it proves that there was no title. You're not dealing with a mortgage, you're dealing with a sale and repurchase agreement. They didn't sell the property, then they don't own it, do they?
Oh, I know that. In my case, before I sent them an adverse claim. I sent the lawyer an adverse claim, and he totally denied and told me that I have no basis for which I'm making, a $1 billion claim. But what I'm saying is that it worked because I think they really backed off. And so I'm just, you're giving it to us from a different angle by saying, go after the title insurance company, which is a good thing. But
you have to file an errors and omissions claim.
Okay. All right. Well, I guess I'll just wait and look forward to, a lesson on what you're doing with that. Thank you.
Okay, this is what I'm going to do. Thursday, we're going to have, is Thursday good for you, Gene? If we do a class on Thursday?
Yeah, that's fine.
Okay, I'm going to set up a class Thursday at, I guess it'll be around 6 or 7, about 6 p.m. our time, Pacific Standard Time. And we'll go through some of these things for everybody. And it'll be an online access. We'll do it online where you can put the documents up. I'll set up everything. And, you can be at your home. You can see everything he's doing on the screen. We'll do it like that. Email me for the details and for the cost. And we'll get all that out to you, okay? Let me go to the next caller. 423. Area code 423. We're going to go dip to Tennessee real quick. 423-3100. You're on High Frequency Radio.
Yeah. How you doing today?
Great. How you doing?
To Gene. I'm in foreclosure right now, and what I was wanting to do is I'm going to do GSA Form 90, and because everything's pledged, Tennessee is a deed of trust, and so I was wanting to release the lien on my property because it's been pledged, because, pledges occur when there's only one signature, and there's only one signature on the deed of trust. So we know that it was pledged into the county. They're laying claim to owning the property. So I was wanting to do the GSA 90 form, and so my question to Gene is, I'm looking at the form right here to fill it out properly. It has the name, and so I'd put my name right there, and then it says place of residency. Wouldn't I put the deed of trust where it's found at the county recorder, that instrument number and the book and page number, or would I put map and parcel there? What do you put at that particular place?
I'd have to see the form that you're looking at.
Okay. I'm looking at the GSA 90 form. Wouldn't that be a proper one it releases the lien on the real property?
Well, there's two forms. There's a 90 and a 91.
Yes, sir. They're both the same virtually when you fill them out.
I'd have to see the form.
Okay. If that form is filled out properly, wouldn't that break that pledge?
Yes.
Okay. And then the next thing I was going to use is a Coast Guard form. It's a release of lien, the Coast Guard form. Because aren't they treating this as a vessel? This deed of trust.
Well, it's a satisfaction of. We actually got them to do that. Yeah.
Okay.
Release of lien and release of mortgage and release of lien. If you're looking at it from a lien perspective.
Okay, and so these filled out properly and sent back to the Coast Guard and to the GSA place. Will they acknowledge it and send me a copy back or something, and then I can show it to the county that it's unpledged? What's the procedure after you fill this out?
Yeah, they have to. I have to look at the form and see what the form says. I don't have the form in front of me.
Okay. Yeah, Yusef, can you look at these forms? Because, see, we have pledged, because that's one of the things Roosevelt said, that we're in a pledged society right now, and we have to unpledge
well, they
our
call
property.
That hypothecation and pledge.
Yeah, and so we got to break that pledge because we didn't do it. An attorney came behind us and fraudulently filled out that pledge. We did knowingly pledge this back to the county. And so I went to a sale here in Tennessee a couple of weeks ago, and when the lady there, at the auction, she says that when you buy this property, all you're getting is trustee's right of possession, see, and it's a private sale. And it's like, how can any of this really go on? Because, we couldn't do a private sale like that on the steps of the courthouse and get away with this nonsense. It's all fraudulent the way they're doing it, it appears.
I mean,
that's what
to me,
when y'all do this Thursday, you got to put together this GSA forms, the 9091, how to fill them out properly, because that's the key. You don't fill them out the way you think.
I have GSA forms or instructions to fill out, but it's for like criminal cases.
See,
the release it's a release on personal property and release on, you got a 9091, release on personal property and release on real property, I think they are.
Yeah.
And it basically you have sections in there where it asks where the property is located.
Yep.
I think you're going to put your birth certificate number in there. All of that stuff is going to go on there. I don't remember either. I don't have the form in front of me. But I have it.
Okay, the key, I think, on this is when you're wanting to break this deed of trust, you have to put where it's located at, and it's located in the county on that recording. The book and page number where that's recorded.
Exactly.
See, that's where it lives. And if you don't put this down properly, they'll just sidestep it. See, that's what a lot of people have done. Gene is one of the few guys that knows how to fill these out properly. What it's actually asking. See, it's asking in a code what the information is. You think you know what it means, but no. And the Coast Guard has got the same identical forms that you got to fill out. You got to fill out both of them, the 90, the 91, and then the Coast Guard has a reflecting of the same thing. Because, see, this is a vessel. So you can have that on Thursday. When y'all do this Thursday, I want to be on it too, and we'll go over filling these out. Because this is the key to foreclosure right here. You got to get your pledged property back, even though you didn't honestly pledge it. They're saying they own it. See, that you gave up the right to it. That's why this is a forfeiture. See, it's a forfeiture from day one. That's why you're a tenant and having to pay taxes and rent from day one. You never own this property because the day you sign all the paperwork, you pledge it over to the county and their holder.
Yeah, it says in the deed
That's why the judge. This is why the judge gets to play the game he gets to play, because he knows that you pledged it over and you have no rights.
This is also in my investigation. I got into a debate with someone that you are gifting the property. That's why there's no need for consideration, because it's an executed contract. When you gift it over, everybody keeps saying, well, there's no consideration. Well, one of the things in contract law that does not require consideration is when you gift something.
Okay,
And,
whenever something's pledged or gifted, look here, here's the rules. When something's pledged or gifted, it only requires one signature to execute. A contract requires two signatures. The deed of trust only has the one that you pledged or gifted over signature. That's how they're doing this game. It's a con game, and it's that easy broken. Gene's the only guy that knows how to fill this stuff out properly, and you know, with this Thursday night, this right here will put us right where we need to be.
Boy, you putting them on the spot.
Well, Thursday's always a good day to do something like this, you know.
Right.
Well,
but I think
there's
so too.
There's no mortgage contract either. If you go up on the Fannie Mae Freddie Mac website, the beneficiary has to sign the deed of trust.
Yeah. Now, as you're mentioning that, Gene, one of the things I'm thinking is you need to fill out two of these 90s, two of them, okay? And here's why. One of them has to do with the deed of trust. The second one has to do with what they're calling a loan number. They're two different items. The servicing, whoever's doing the servicing, the bank servicing agent, has that loan number that he's hanging on to and thinks he should get future payments from that, see? And then you've got the deed of trust, which is recorded at the county. Two different worlds. So you're going to have to do two different, for each one of those accounts, one for the deed of trust and the other for the mortgage account that the servicing agent is hanging on to. So you're going to have to do two of the 90s, two of the 91s, and two of the Coast Guard release of lien, and put those separate numbers, account numbers in there. Is that making sense?
Yeah.
I'm sorry, I got blocked out for a second. I guess you're talking about the 90 and 91 form?
Yeah, let's just stay with just the 90 for a moment, okay? When you fill it out, you're doing one just for the deed of trust, which is located at the booking page in the county. All right, you do a second one to kill the pledge on what they're calling the mortgage account. Separate items. The mortgage account is going to the servicer, and that's who's coming after you with both of these. So you need to kill both of them. The servicer, his account, which he's calling a mortgage account number, and then you need to kill the deed of trust, which is with the county where it was pledged there too. So this is two different pledges that you're going to have to kill with just one 90, two separate 90 forms, two separate 91 forms, and two separate Coast Guard release of lien forms.
It would just appear to me, though, that you would need to give some 24, 25, and 25A, because you have to give some sort of instrument to satisfy the obligation, like a bond or bill of exchange or a promissory note or something. That's just my opinion. That's my opinion on it.
Okay, could you just use the deed of trust for that? Have just a copy of the deed of trust with a 28?
I don't see how that would constitute a negotiable instrument, a copy of it. I mean, why not just give them a bond? I mean, or, a bill of exchange. Give them some type of negotiable instrument. I'm always of the mindset you give them, when I stepped on the scene, I didn't argue with the people. My thing was give them an instrument, give them something, because there is no money. There's no money. So if they're saying I owe them some money, and under House Resolution 192 of June 5th, 1933, Public Law 73-10, codified at Title 31-511-AD2, which is the rescission of the gold clause, and there's no constitutionally mandated money of exchange being utilized in the public, you cannot tell me how to pay you something. So basically it's just constructing an instrument properly where it can be recognized, that it can have a legal recognition, which is why they have this Universal Convention and, Article 3 of the UCC. That's just my thinking. And that these standard forms are just what they say. They're standard.
It's just a standard form, you know, and that's just my thinking. But I could give them something, give them some sort of negotiable instrument with your signature on it that will satisfy the obligation and have evidence that you've done that. That's what I call staying in honor at all cost. If you dishonor these people, and there's a lot of ways to do it, that's what they're going off of. It's all about honor and dishonor. Honoring and dishonor. It's a game. It's really a game is what it is. It's a game.
Yeah,
it
absolutely.
Literally is a game.
What does Gene think about putting a negotiable instrument in with that 24, like you're saying? I think it's a perfect idea.
Yeah, you can do a 24. You can do a bid bond, a performance bond, and a payment bond. All of this is that's all maritime law. What you're doing is indemnifying them against loss. That's why all of these mortgage foreclosure cases are indemnification and contribution. Because what they're really doing is you're indemnifying them against loss. Okay, but they can't get contribution, they can't extract contribution from you if there was a degree, if there was, see, it's called primary and secondary and active and passive. If you have active liability or primary liability, that's called degree of fault, and that's what all states go by. It's all controlled by state statute. Contribution and indemnification is. And it's by degree of fault. If you committed an overt act that contributed to the loss, that constitutes primary and active fault, which means you can't get contribution. So what they're doing is they're getting contribution from you. They're getting you to pay for their default or their claim that they created.
Hey, let me interrupt real quick. Let me make a quick announcement. For everybody listening on the internet, we got about 90 more seconds on the stream. So if you want to continue listening, we got about an hour left on the show. You can call in 424-222-5250, or you can Skype in. Once again, that's 424-222-5250. You're going to have to call in now. If you choose not to continue with us, then you can catch all of our archives at blogtalkradio.com/high frequency. You can catch this show and other shows that we have held in the past. You're listening to High Frequency Radio with special guest Jean Keating. Okay, go ahead, Jean.
Okay, the two forms that he's talking about is the 90 and the 91. The 90 is a release of lien on real property. So you're asking for a release of lien on real property.
Okay, and we can go over that Thursday, right, Gene?
Yeah, we can go over all that, and this is by a bond for the performance of U.S. government. That's Form 25. That's the performance bond, and the 25A is the payment bond. What they're doing, all these courts are under the CRIS, under the DLIS, Defense Logistics Information Service, which is under the DOD. They're using you as the surety or bonding company to bond their contracts, their government contracts. It says by a bond for the performance of a U.S. government contract. See, they're all bankrupt, so they have to use your money. That's why all these loans are all bond contracts. That's why it's an insurance contract. And that's not me saying that. That's Michael Greenberger. He said that all of these mortgage loans are credit default swap agreements, which are insurance contracts. He said that. They're disguised insurance contracts. And the reason they disguise them as a default swap agreement is so they don't have to put up the insurance money to indemnify them under the state law, because state law governs insurance contracts. And it demands that money be put into an account to indemnify the insured against default, loss, or risk. So you have to have the money in place. If it's a credit default swap agreement, you don't have to have, because they've been deregulated. There's no regulations governing them. So what they do is they disguise them as credit default swap agreements when you really have an insurance contract, in which they're forfeiting the bond at closing to cover the default. I called up Paladin, who does forensic audits, and told them what's going on. I said, let me tell you what's going on. They have 23 mortgage bankers that do the audits. I said, they're forfeiting the bond at closing to pay for the default to the title insurance and the investors and the servicing companies. You're absolutely right.
Wow.
He told me I was absolutely correct. So what I did is I called up because these title companies have to have, in order to have title insurance, you have to have a bond in place. State law says that they have to have a $500,000 bond in place. So I called up the state insurance division up in Sacramento. And I said, I want to see a copy. I told them I was an attorney. So, I told them, I said, I need a copy of the bond. And I said, do they file the bond with the Commissioner of Insurance, or who do they file it with? And he told me that they file it with the State Treasurer's Office up in Sacramento. So I called up the State Treasurer's Office and told them I want to see a copy of the bond. Well, this is Federal Home Loan Mortgage Bank Corporation. That's the bonding company. And they put up a $500,000 bond. Guess what the bond is? They sent me a copy of the bond. It's a promissory note. And you're telling me promissory notes are not bonds? That's what they put up to indemnify them against loss. So what the hell do you think they're doing on these mortgage loans? You think you've got a liability instrument, mortgage note, promissory note that's covering a liability on a loan of money that was borrowed from a servicing company as a mortgage loan. What you're really doing is putting up a bond to indemnify the investors and the servicing company against potential default in the event of a default. Well, they put the loan in default at closing by not transferring the loan documents to the REMIC. And the reason they didn't transfer the loan documents to the REMIC is because they never formed a real estate investment trust by filing a 1066 REMIC tax return at closing. They not only didn't file a REMIC tax return under 857 and 856 of Title 26, they didn't file a statement to treat the property as foreclosure property. So they're sitting there with all this capital that they've foreclosed on, and they've declared property as foreclosure property, which creates taxable income. And the reason it's taxable income is because it's a disposition of property that creates taxable income. They're disposing of property. When you dispose of property, that's a default. They have to report that on an RCN or an RCS, RCP, which is a call schedule. They have to report that as income. You ought to see what I'm going through. I'm calling up the FDIC, Federal Depository Insurance Corporation. I said, you guys they connected me with an analyst. And I talked to the analyst. I said, do you know what a call schedule is? He said, yeah. And I said, what is it? He didn't even know what a call schedule is. I said, who are you kidding? You guys are a bunch of buffoons. And so they connected me with the comptroller of currency, because a particular company that I was, you guys still there?
Yeah.
Yeah, we're here. What?
He said because the particular company that you're dealing with is what the name of the company is World Savings FSB, World Savings Bank FSB, which is a federal savings. Well, what happened, and this is a 2004 loan, so they had to put up a TFR. It's called a Thrift Financial Report because they're a federal savings bank. They're not a National Banking Association, which is under the Comptroller of Currency. So they did away with all the federal savings and loan associations, so everything went up under the call reports instead of the TFRs. And so I called up this congressman. I said, you people don't know what the fuck you're doing. I told this congresswoman like that. I said, you guys need to go see a proctologist. I told him that I do head extractions on the side. I have a proctologist. I'm a working proctologist.
Well, that's the way they are. They want to sidestep the issue so that they
oh, yeah, they're avoiding the issue because there never was a loan. And so what they do is they have to report that as income.
But they
Remember,
don't.
Receivables are assets that are owed to a bank. That's income. And if you read FASB number 95, Statement of Cash Flows, when a loan is taken out, a payment is made to the depositor and a receipt to the bank, and a payment to the bank and a receipt to the depositor. So both the depositor and the bank get a payment and a receipt. I said, well, where's my receipt for the payment at closing? I said, I have the instrument in which to buy it. I said, the note, which you call a liability instrument, was treated as a draft, and you endorsed it for payment. You deposited it in a transaction account using a qualified restrictive endorsement, which just discharges the drawer and the maker. And I want the receipt for my payment at closing. Oh, they have a canary. They have a canary. I said, you didn't treat this. I said, are you telling me that you have are you telling me that you can treat a note as a liability instrument on a mortgage loan and as a draft, as an asset that was endorsed for payment to the seller to pay for the property? I said, where, under what code section, Uniform Commercial Code section, can you treat a liability instrument as a draft and then foreclose on the liability instrument?
Here's the thing, Gene. They're in default from day one.
And I said, you endorse that as a drawee payee under 3-413. That means that you endorsed it for payment, and you're liable for the payment to the drawer and the maker, which is the alleged homeowner. You owe him the money for the money that you endorsed for payment.
Well, see, they're in default. Aren't they in default day one when they don't report to you the correct, when they lie and cheat? They're in default that moment, aren't they?
Well, you're not dealing with a liability instrument, so there is no mortgage. So how can there be a default if there's no mortgage?
Yeah,
what they did is they sold the security bond as an investment contract to investors. And they never transferred the instruments to the REMIC because they never qualified the REMIC as a real estate investment trust, number one. And they never filed a statement to treat the property as foreclosure property. That's number two. And they didn't transfer the loan documents within 4975 within the first 90 days of the safe harbor provisions of 4975. So you have three prohibited transactions, which carry a $50,000 fine for each violation. And you have 100% tax liability under 4975 for the prohibited transaction and for the violation. You have a 15% penalty for the violation and 100% tax liability for the prohibited transaction. So you have 115% payment due to the IRS. That's why this whole thing is a tax liability.
Well, let's come back full circle then, the tax liability.
Yeah, it's what you're dealing with is a 100% tax liability. You're not dealing with a mortgage foreclosure case, and what the servicing company is doing is acting as a backup withholding agent for the IRS.
Okay.
So they they do a forfeiture to pay for the default that they engineered at closing.
Okay, could we put in a negotiable instrument once again, a second one, and that clear the books for our liability?
What nobody understands is that the borrower was the servicing company. They borrowed capital from investors who put capital into a REMIC at closing. Well, so they're using your property as the collateral for the loan that they borrowed from the investors. So the investment contract is the pooling and servicing agreement that was signed by the servicing company. They can't hold you liable on a contract that's not memorialized or subscribed to by the person being charged. Where did the homeowner sign a pooling and servicing agreement agreeing to make payments to the servicing, to the investors as an investment contract? And where did they get the authority to make money off of a mortgage loan in violation of 1639B of Title 12? That's a violation. You can't make money off a mortgage loan. They're making money off of an investment contract, not a mortgage loan.
That makes so much sense, Gene. You're saying that the promissory note is actually a check. That's why they endorse it, paid to the order. So they're not treating it as a liability instrument.
Well, read 3-104D. 3-104D says that if it's a liability, a promise to pay is a liability instrument, an order to pay is a draft. The person entitled to enforce it can treat it as either. So once they treat it, okay, let me ask you a question. I make out a check to you. Pay to the order up. And I give you that check. That check is a liability instrument until you endorse it for payment. If you take my check, turn it over, and endorse it for payment, and deposit it in a demand deposit account, you've been paid. It's no longer a liability instrument. It's an asset.
It's that simple. It's that
simple. You gave them a draft, they endorsed it for payment, and they got paid, and I can prove it. End of story. So what's all this shit about a foreclosure?
Damn.
I paid for the fucking property with a draft, which is a check. Go look up the definition of a draft under the Uniform Commercial Code. It's the same thing as a check. What they did is they took a liability instrument, treated it as a draft, and endorsed it for payment and got paid. And they have the receipt for the payment, but they didn't give you the receipt because you didn't ask for it. Go read FASB number 95, Statement of Cash Flows. I did a letter rogatory to Judge Worley. I said, "Where's the damn?" I said, "If you do terminate my interest in this car," I did this with Toby. I filed a letter rogatory with the judge. You know what the judge did? He took both cases off. It was a $40,000 truck, Ford pickup truck, and an $80,000 Honda Hyundai, which is an $80,000 car. He took both cases off calendar and granted summary judgment to Toby just by me filing a letter rogatory. And I put the pooling and servicing agreement in there showing that the Toyota Finances sold the retail installment contract, because when you take out a loan, you fill out a retail installment contract. You know what they do with these retail installment contracts? They treat them as a payment intangible under 9-102. You know what a payment intangible is? It's a receivable. You know what a receivable is? They use the receivables on the installment contract to pay for the certificated securities and bonds that they buy from the investors. So they're using your retail installment contract as receivables to pay for the certificated securities and bonds that they buy from investors at closing. Now this is on a car loan. And I have the Citizens Auto Loan Trust 699-page prospectus. I can show you. I'll show you this on the class Thursday. I'll show you the prospectus where it actually says that. They use the receivables, which is the retail installment contract, to pay for the certificates and securities and bonds under the trust agreement to Citizens Auto Loan Trust. So they're using your retail installment contract as a payment intangible to pay for certificated securities and bonds, which is an investment contract. Doesn't have anything to do with a loan.
That makes perfect sense. Makes perfect sense.
I got 699 pages that says that. I went through that whole 699 pages and copied every section out of it. And that's something that the public never sees. And I can show you, I put this into the letter rogatory. I copied the pooling and servicing agreement out of the letter rogatory, and it has a flow chart in it, a 2-page flow chart. And I showed the judge where the receivables are transferred from the trust account into a trust agreement, Citizens Auto Loan Trust, which paid for the car.
Can we ever ask the bank for any of this accounting information and they give it to us?
Well, nobody makes them produce it. They have to produce under the U.S. Patriot Act, and I have the code sections that say that, and all these courts are operating under the War Powers Act. So they're under the Patriot Act. And they're required. You know who Mitchell Stein is? He went into a courtroom with Bank of America, and Mitchell Stein runs Stein and Associates out of New York City, and they have a case in New York where they filed suit against against Bank of America. And I have a copy of the complaint. And the judge ordered them to produce the CMIRs, the Currency Money Instrument Reports, FinCEN Form 104, 105, and 8300. Also, when you go to closing and you take a note and you deposit it in a transaction account or a demand deposit account under 1813 L1 of Title 12, it becomes the equivalent of money or cash. So you have a cash transaction of more than $10,000 that's reportable on an 8300 form as a cash transaction. Now, how come people aren't doing that?
We got to start asking for that information.
You got to make them produce the 8300 form. Make them produce the 8300 form that shows there was a cash transaction. See, they don't report that stuff. They're treating it as you can't treat an asset instrument, a draft, as a liability instrument. What they're doing is double dipping. They're saying we can treat this as a liability instrument and collect money to you on the mortgage side, and we can turn around and treat it as a draft and pay for the mortgage using your money. And then we can foreclose on the property because it was in default because of there never was a loan. Guess who owns the eminent default indicator, which is a patented copyright instrument? And I have the actual copyrights, and I'll show them to you on the class on Thursday. The U.S. Teresa Ria, who's the acting director and secretary of the USPTO, every lawyer that goes in there and forecloses on property has to be certified or authenticated by the director of the USPTO because they're working on private copyrighted law. The eminent default indicator is a private copyrighted patent. Now, how can they predict when a loan's going to go into default and say it's eminent unless they're controlling the default?
Wow.
Yeah, wow.
Wow.
Hey, how do we sign up for Thursday's class, Yusef?
You're going to email everybody.
You want me to give you my PayPal account so they can send the money to the PayPal?
Well, actually, I'll handle all that, Gene. I got that. Email me at highfrequencyblogtalk@gmail.com, and then me and Eugene, we get off the phone. We'll set up all the arrangements and everything. But email me at highfrequencyblogtalk@gmail.com.
Right, because we need these forms. We need to go over these forms, the 8300 and stuff like that, Gene.
Okay, it's called High Frequency.
Yeah, High Frequency Blog Talk. That's the Gmail. I emailed you from High Frequency Blog Talk. That's where I emailed you from. High Frequency Blog Talk @gmail.com, and I'll call you as soon as we get through with this telecast.
They cannot prove that there ever was a loan. What they do is they work on presumption. What does 1-201 of the Uniform Commercial Code say about, and I think it's been changed to 1-308. What does it say about presumption? The trier of the fact shall find the fact to exist if evidence isn't put into the record to show a contrary finding.
Well, see, that's the problem. This is non-judicial state, Tennessee and Georgia is, and so it never goes to court. It's all done outside of anything to do with fairness.
Do you know what they're really doing? And nobody, did you know that under the under Section 20, have you ever read 2924? I haven't met anybody that's read 2924. There's three different estates in 2924. There's an estate for years, an estate at will, and an estate in real property. What does that tell you? What's the first clue that gives you?
Yeah, the will at real estate.
Okay, it's an estate at will, an estate for years, and an estate in real property. And it says that in order for the trustee to exercise the power of sale, there has to be a decree or judgment from a court of record. Well, guess where that court of record is? It's a probate court. Under 725 and 726A of the CCP, Code of Civil Procedure. Go read it. They have to file a complaint for foreclosure and get a decree or judgment from a court, it says a probate referee. What the fuck is a probate referee doing on a foreclosure case? Because the reason they have a probate referee is because you got a dead person. So what he's doing is probating the estate.
Yes, and we don't know about that common law court because they do it in secret.
Yeah, they do that in the probate. That's why they issue, when there's been a POD, and every state has adopted the Transfer on Death Act. And what that does is when you die, if you have a legal estate and you die with no beneficiary or heir of record, now get this, of record, the estate becomes a testate, and it escheats back to the county. The county appoints a probate officer or a surety company who issues a refunding bond that indemnifies the probate from liability in the event that the real beneficiary and heir shows up and claims the property. So what's really going on in these foreclosure cases is they're doing a TOD, a transfer on death. And they issue a refunding bond to indemnify the probate from liability in the event that you show up and claim the property as the beneficiary and heir. So I go into the court under intestate succession, under descent and distribution, as the administrator legitimus. That means the administrator by law. I'm the heir beneficiary at law, by intestate succession and by descent and distribution under the California Probate Code.
I actually understood everything you just said. I must be getting good with this. I understood everything you just said.
Now, under rule, under the understanding and capacity, there's been ratification of commencement because I'm a real party in interest, because I have capacity to bring a claim, because I'm the executor of the decedent's estate. And they're actually using a dead person's name without my permission.
And you can get the distribution that the probate is distributing that estate, and you qualify to receive that. Is that what you're saying?
Right. Yeah, I'm entitled to payment.
To payment, exactly. Makes a lot of sense.
And what they're doing is, and TOD means transfer on death. So what happens is the estate and the real property transfers over to the county because this is how they probate your estate. And that's why they call it transfer on death. And you don't have to have a court order, and you don't have to have a will for the transfer to occur. And so what they also do is a POD, payment on death. So what I bring up is the fact that, what does it say in 3128? When there's an official record declaring the estate, that is sufficient evidence for credit to a Federal Reserve Bank account. Go read 3128.
It's Title 26?
No, Title 31.
Okay, Title 31, Money and Finance, okay.
So you have actual evidence, so I called up the IRS, got them to fill out an SS form for him, declaring me, Jean Keating, to be dead. So now I can credit, I got evidence from a government agency that says I've been declared dead.
That's like collapsing the trust. Wouldn't that be a key?
Yeah, that collapses the trust, and now they can credit money to your account under 3128.
Wow. And you have to have an estate and a trust set up on the other side to have that
right.
Too.
That's where the foreign grantor trust comes in.
Woo! I don't know if everybody is listening and don't even understand what the fuck you talking about. I'm not trying to call people John, but I don't know if they know how just valuable information he's kicking right now, because I've been reading about this for the longest, and he just put a couple of pieces together for me. Y'all should.
Well, what they're doing is everything is based off where did probate law come from? It came from ecclesiastical law, An ecclesiastical law came from canon law. Why do you think all these judges, and all of them, every judge files his oath of office with the cardinal bishop in the diocese in which the court is located? So when I do a case, I do an X-ray-L in the name of the cardinal bishop. As a relator, X-ray-L, in the relationship of the cardinal bishop, because he's got the bond of the judge. They recorded their bond and oath of office with the cardinal bishop. Under ecclesiastical law. It's all under ecclesiastical law.
Wow. Hey, I gotta take some more calls. Let me take another call.
This might be the best call you've ever had.
I would say it's one of the best. You know, it's definitely one of the best.
It's hard to say, but this is up there.
Jewels. He dropped some serious jewels. He really did. He really did. That's all I don't think people know. He just went in his zone. He just went in his zone just then. So yeah, I know it was a good call. Gotta let him flow. I appreciate it, man. Appreciate your call. Let me grab one other call. We'll try to grab a couple more calls. And thank you for calling, man. All right. Let's go to area code 646. You're on the air. You're on high frequency. 646-4187.
I'm just listening. Sorry.
Oh, okay. Okay. All right. Let me.
You gotta learn before you can. You gotta learn before you can walk. You gotta know how to walk before you can walk. You gotta learn this stuff so that you don't. Then the wisdom comes in. Wisdom is the application to take knowledge and apply it, and that's what the scriptures say. Knowledge without wisdom is worthless. Wisdom is the capacity to take knowledge and to apply it.
Application of knowledge. Virginia, 747 area code 757. Virginia, you're on the air. Virginia, 757. Okay, let me go back to, let's go to 615 area code. You're on high frequency radio.
Peace.
What's going on?
Can you hear me? Hey.
Yes, I can hear you. Tennessee.
Yeah, Brother Eric, Tennessee. Doing pretty good, brother. I've been trying to reach you. I know you're a hard man to reach these days.
You know what? I want you to call me. I need to talk to you. I was trying to call you yesterday. I could not find your number. I'm glad you called me today. I'm trying to call you.
So
as soon as this call is over with.
Is the Atlanta number still good?
No, it's not. I have a new number. But I'll call you when the show. I'll call you first as soon as the show is over. I was trying to call you yesterday.
Oh, we got a lot of things to talk about, brother. Let's get on it.
Right.
Yeah,
right.
Yes, sir. All right. I wanted to ask a question, man. We basically try to stop a foreclosure from a relative, and we had it assigned to the trust. And just to test it out, we had the relative still go into the court, and then the attorneys basically said that the relative being could not come into the court, which they were correct. They're acting as a grantor once public record showed that it was assigned. So my question is, if I'm going in as the trustee, all the things that Mr. Keating is talking about, does the trustee of the trust who's been quitclaimed this house, can it perform and ask for the same things now that it has interest? Can it ask for the same material or ask for the same proving, since the trust is actually not the person who signed the mortgage agreement? Can the trustee still approach this the same exact way?
Well, he has to file. He has to make an appearance in court to give the court jurisdiction. The trustee can represent the trust. Yeah.
Okay, but what?
Grantor.
So well, they were saying that the grantor could not make a claim. That's what the judge ruled.
Based on what?
I guess based on us not knowing any better and going for it. But that's what they say.
Well, tell him you want a finding of fact and conclusion of law.
Oh, okay. I got you. I see. I didn't know that the grantor could go in, so I said, okay, well, the trustee has to go in then. And
well,
so
the grantor owns all the trust assets. Go read 671 through 679 of Title 26.
Gotcha.
When you transfer the grantor has in fact, the grantor has the power. Go read the power of 1951.
Gotcha. The Power Appointment Act?
Yeah.
Yeah, I've already read that one. I used that one in a case once. You're right. On the Power Appointment Act, you're right. That would be correct. Gotcha. I like that one.
Hang on just a second.
All right.
Okay. Yeah, Yusef.
That's under the Power of Appointment Act. You have the right to. You got all this power. You can appoint anybody you want as and nobody's.
Well, remember, Mr. Keating, that we did what
everybody should be doing is correcting the birth records. Then you don't have any of these.
That's true. But in this case, you remember
where all this came from?
Yeah, to some degree. Yes, sir.
Okay,
and this
where
is
did
in Tennessee.
it all come from?
You talking about as far as the trust scenario, or are you saying as far as their ability to foreclose?
Okay, well, have you ever heard of the dead man statutes?
No, I haven't.
Then you don't know what's going on.
Gotcha.
Okay, dead man statutes they were passed in the early 1800s, and what the dead man statute says is that a person cannot come into a court of law and give fact testimony on behalf of a dead person. And most of your states repealed the dead man statutes. You know what they did with it? They codified it to Rule 601, competency to testify.
Wow.
That's where Rule 601 of the Federal Rules of Evidence, and all your states have the same rule, except they may be numbered differently, but that competency to testify comes from the dead man statutes. Now, how can a person who's going into a court and using a dead person's name give fact testimony as a fact witness when he's testifying as a dead person?
I see, and I think I'm just been understanding.
And how can you have under 602? How can you have personal knowledge? In 603, how can you swear under oath or by affidavit if you're incompetent to testify?
You're not going to be.
So, and under 1001, there's no authentication under 901, 902, and 903, and 1001, and 1002, and 1003 of the Rules of Evidence.
Gotcha. And I think I want to tell you that, make sure that I'm telling you correctly. We didn't. The trustee, the mortgage owner did not just grant it to the trust. They quit their claim. They did a quit claim to the trust. Is that a difference? You understand what I'm saying?
You can quit claim it if you see. Here's what the problem you run into. If you read your deed of trust, it says in the deed of trust that I hereby grant and transfer. Well, at the time that you signed at the time that you signed it, you it's some language and here's the language. The borrower has signed an agreement stating inter alia that for good and valuable consideration, receipt of which is hereby acknowledged and being fully sized of the property, which means fully owning it without any encumbrances. I, the borrower, do hereby enter into this agreement to mortgage said property as fully described in this document by virtue of my appointment as trustor, and do appoint as trustee irrevocably for this purpose the name of the trustee who works for the title company handling the transaction. A document has been written which clearly states that the buyer admits to having received consideration of some type prior to this point in time. In exchange for what? He admits that he owns the property free of all debt, otherwise he could not mortgage it. The escrow company agrees with him that the property at this point is free and clear of debt, or else they could not serve as the intermediary fiduciary party certifying these assertions as facts. But this begs the very obvious question. If the borrower already owns the property, why does he need the mortgage? Unless he is borrowing money to be used for some other private purpose of his. If he uses the property as collateral for the loan, when did he receive the money? Has the borrower or has any party involved ever received money from the mortgagee? What is the answer?
No, nobody ever received any money.
Well, then how the hell can they foreclose on property?
Because they're saying that we signed a death mortgage, which they turned it into a debt instrument. And saying we made a pledge.
Yeah, but if this is, it says, I hereby can transfer and convey all right, title, and interest in the below described property. And if it's a trustee under a deed of trust, if it's a mortgage security company agreement, it's to the beneficiary, which is the mortgagee. So whether it's the mortgagee or the lender you're transferring the lender you're transferring it to, or a trustee, in order to transfer and convey right, title, and interest, there has to be a preliminary change of title and ownership form filed. And the transferee buyer has to pay the Capital Transfer Act under 480.03 of the Revenue and Taxation Code. They have to record a 502A preliminary change of title and ownership form, which they never do. And if you read the insurance code 12421 of the California Insurance Code, before they can go to closing and transfer funds to a trust escrow account in a financial institution, the capital transfer tax has to be paid by the buyer transferee prior to closing. It says that in the escrow instructions. That never occurred. So there never was a transfer of funds into an escrow trust account by a mortgagee lender at closing. So the mortgage company, the mortgagee, never owned the property as security or collateral for a loan. And in Florida, I was talking, I didn't know who that young lady was that brought up that she had a warranty deed. They never paid the capital transfer tax on the note. In Florida, you have a capital transfer tax on the note.
Right.
Well, when you're transferring the note, I have a Florida case that says the note is unenforceable if the capital transfer tax hasn't been paid.
So basically, it doesn't matter that they're trying to use the fact that we're in a private contract with them. They're forfeiting everything because they're not following the correct procedures of that private contract.
There's no contract. If you go into California and pull the fictitious deed of trust. A fictitious deed of trust is a Fannie Mae, Freddie Mac form. It has to be signed by both the lender. That's why they call it a fictitious deed of trust. And they take the word fictitious out of it, and the fictitious one is never filled out or signed by anybody.
Well, I'll be on Thursday's class. That's no doubt.
All right.
They're getting away with murder because nobody knows what's really going on in the courtroom.
Yeah, but Gene, I got to figure out how to fight my way back over there because they're still got me stuck on the fact that the claim has been quit. So they're saying you hire you in if the claim's been quit, so you can't bring these things in. Is what they're trying to tell me.
They're saying that the claim has been what?
By doing a quick claim. That they're not letting us. We have to fight our way back in now to even make these points because we didn't just assign it to her assets to a trust. We quick claimed it into a trust. So she quit.
Are they trying to foreclose on the property?
Yes, they are.
Based on what?
Based on the fact that they're never going to produce anything, and we ain't going to pay them until they produce it. And we went to court with them, and I didn't want her to go in as an elderly person, so we just did the trust. But I didn't have her assign it to the trust. She just quick claimed it, and our trust picked it up. But she's still a grantor on the trust, but it's under she quick claimed it, and where it's quick claimed and picked up is by the trust that she is a. Does that make any difference? Do you
have a judicial or non-judicial?
I'm in Tennessee. It's non-judicial.
So it's a trust state.
Yes. Yes, sir.
Okay, so the trustee never had title to the property. That's what you should be arguing. Where's the preliminary change of title and ownership form, and where is the capital transfer tax for the transfer of title? Every state, when you transfer title and ownership, you have to record the transfer. Or it's void against all subsequent purchasers for value and consideration. The transfer is void against all subsequent transfers and purchasers for value unless the transfer is recorded. Where did they record the transfer of title and ownership at closing?
The title company on this loan actually went bankrupt because they were actually they put themselves down as they did some illegal stuff in a lot of places, and so they just went ahead and bankrupted the title company.
Well, the title company is not bankrupt. If the title company goes out of business, they always they replace them with somebody else. I bet you it's Fidelity National Title Company out of Jacksonville, Florida. And you know who owns them? They're an investment company. They're owned by Wells Fargo Bank. Gotcha. And there's no title in policy. Go get the policy, dig out your title policy, and you know what it'll say? That it doesn't cover a mortgage in the Schedule B. See, until 1933, in 1933, California had a rule that a deed of trust is not considered a mortgage. That all changed in 1969. As of 1969, the California Supreme Court ruled under 2920, a mortgage is the same as a deed of trust. So it's a mortgage. It's a deed of trust and a mortgage.
Yeah, this mortgage originally started with Taylor Beam and Whitaker, which their CEO went to prison for selling the bad paper. And they
have to do a preliminary change of title and ownership form before they can, as a transferee, buyer transferee, they have to pay the capital transfer tax before they can have title, because it's Adam Leventon who works on the American Law Commission that does all the revisions on Article 9. Under 9-203G, under the common law transfer rule, when a seller sells a mortgage, a deed of trust, and a note, he becomes a debtor. The buyer becomes the secured party creditor. And under 9-318, the seller-debtor retains no legal or equitable interest in the collateral or to the payment that is sold. Well, all you got to do is produce the pooling and servicing agreement that shows they sold it to investors.
We already have that. We already had that, and we put it into the case. But then
they didn't retain any legal or equitable interest in the collateral sold, because a note becomes collateral when it's sold under Article 9. Nobody brings this up. And under the common law transfer rule, under 9-203, there's no enforceability of a mortgage lien under Article 9. So whoever owns the note owns the mortgage. So they sold it under the pooling and servicing agreement to investors. So they have the standing. They're the only people that have right to come into court and foreclose. But they never transferred the loan documents to the REMIC. So the REMIC doesn't have ownership of the property because they never transferred it.
Well, they did, in fact, almost a year. When they saw that we were going to go to court, then they tried to go put it to a REMIC, but according to the IRS laws, according to the REMIC law, rather, that it's
well,
not
under the New York Estate and Trust Law, 7823, and I've got all the code sections, if they don't transfer it within the safe harbor provisions, the trust is void.
Oh, yeah, they've already voided the trust, but the judge keeps throwing us off with the other stuff. He doesn't let us get to the meat because he goes in on the fact that the claim has been quit, and then he dismisses it.
Okay, but the trust has no enforceability if in fact, all of here's where the tax issue, all of the capital that they're holding under 2036A of Title 26 goes to their estate, becomes part of their estate, because they never transferred it to the REMIC. That's why it's all a tax issue.
So should we go ahead and even just start to file the IRS documents and start attacking them that way too?
Well, I would file a 1099-C cancellation and tell them if the judge doesn't admit, you're going to show the judge as the recipient on a taxable termination, and he's going to be the recipient of the funds on a taxable termination under 2601.
Well, they're saying that
2603.
They're saying that Freddie Mac is the owner of it because Taylor Beam foreclosed and bankrupted, and Taylor Beam bankrupted, and when it bankrupted, they're saying that his assets were taken over by Freddie Mac.
Well, they don't have any assets if they're bankrupt. Any corporation or company or association that's bankrupt is civilly dead. Any corporation, company, or association that's civilly dead is naturally and legally dead. Did you know that?
A little bit.
I've got I got about 6 Supreme Court decisions that say that.
We talk about that on this show all the time, civil death. Hey, well, look, y'all, I don't mean to interrupt, but we are out of time. We're out of time. I'm
trying to let y'all go. I want you to go all the way, but I don't want people to get cut off while they're talking. We're out of time. But I want to thank Jean Keating for joining us today. We are going to do a webinar this Thursday. Email me at highfrequencyblogtalk@gmail.com. I'm going to get off the phone and hammer out the details with Jean. But just email us, and I'll put you on my email list if you're listening, and you'll get the notification. I'll send those out today, and I'm giving people ample time to, prepare for the class that is going to be on Thursday. I want to extend another thank you to Jean Keating. Jean Keating is an individual who I first found out about in 2007, 2006, around that time. And my first thing ever reading from Jean Keating was the Jean Keating transcript, which is one of the best documents on the prison industry. To this day, still, I think it's the best. There's nothing else. As a matter of fact, if you go back in my archives and read the top 10 documents that you can read, you will see that in my top 10 documents, the Jean Keating transcript and his documents are on there. He also has a document on the internet called Securitization 101. I don't know if y'all know that. I don't even know if he knows that. But it's one of the best documents I've read on the securitization, where he explains some of the things that he's talking about right now. Very good document. But what we're going to do is we're going to have a class and go into a lot of these things, the GSA forms, a lot of things that you heard discussed on this show today. I want to thank Jean for coming in. I want to thank all my listeners for listening to the show. We'll be back tomorrow. We're going to have a question and answer continuation from last week with Jelani Bay and some of the other brothers. Going to be a roundtable discussion. You definitely don't want to miss that. Wednesday, I'm going to have Dr. Imani. He is a healthcare practitioner. He's going to be on Wednesday and Friday. I'm going to have Sherry Peel Jackson. She is an ex-IRS agent. She is going to be joining us. It's going to be a very interesting show. But anyway, I want to thank everyone. Jean, thank you for showing. Thank you for coming today. Excellent show. Excellent show. I will give you a call in a little bit, okay?
Okay.
All right. Peace to everyone out there. And I will see you tomorrow. Thank you for listening to High Frequency Radio. Peace, all guys.
High frequency. Yeah. Sync up. Already. Yay. I get up with the frequency.